Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us as we are continuing our coverage of Ohio versus Bionca Ellis. Appreciate you guys joining us today. We're just going to dive right into it because they are on a verdict watch. So I called the news station today and they said, nope, they're not going to be streaming live, But what happened was they indeed streamed closing arguments live. So we're going to show, so we're essentially on verdict watch, but we're going to show some testimony while we're in verdict watch. So let's get straight to some testimony that we missed from Friday. So just give me a moment. While I get myself set up here. All right, so this is testimony from Friday. It starts with cross-examination of Dr. Sarah West. She is, this is the defense. Yeah, this is the defense.
You've indicated that you've testified for primarily the defense, but in fact, you've also testified for the state.
Yes.
And that was in Portage County.
Yes.
All right. So, Mr. Mack started with Exhibit J, the competency. But we can all agree, Doctor, that Miss Ellis, when she was questioned about informed consent, at all times that she was questioned about that, to give that informed consent, she was able to understand everything you were talking about. You agree?
Yes.
Okay. And that was not only from the time she was in jail, but at the time she went to North Coast, to the time that Dr. Testa interviewed her, Dr. Vanderkar interviewed her, and then you interviewed her a month later. Is that fair?
Yes.
So Mr. Mack goes through State's Exhibit J. I don't know if you still have that up there.
Yes, ma'am.
You do? Okay. Which bears your name and your signature?
Yes.
Right? Well, before I go any further, what does Argent Apple stand for, ma'am?
That's my private LLC, sole proprietorship LLC.
All right. So are those your offices that you provide these forensic scientific services?
Yes.
Okay. All right. So when you meet Miss Ellis for the first time, have you gotten all of her psychiatric records?
No, I had not.
Okay. So when you are doing competency, you have some limited knowledge. Is that fair?
Yes, I did not have her medical records.
And at that time, you are relying on what other folks have observed.
I am relying on my observations at the time when I meet with her.
At that time, but what I'm saying is you have some limited documentation from the jail, right?
Yes.
That you are reviewing. These are other people's interactions with her, other people's observations. You're looking at whether or not she's taken her medication or that she's refused it, right? You look at all that before you even begin yours. We haven't begun yours yet. When you first get there.
Are we referencing the competency report?
Yes, I'm just talking about competency right now.
I did not have access to a great deal of information. This was only 1 month after the events occurred, and mainly relied on my interview with her to assess her present mental state in order to offer an opinion on competency.
While there's a pause there, just, you okay? Okay, go ahead.
Thank you, Judge. So your mental, Doctor, forgive me. I haven't numbered your pages because there's no page number, but we're going to go to your psychiatric history.
Yes.
Okay.
And is this the September report or the May report?
This is the July 8th, 2024.
July 8th, thank you.
This is the initial competency, right? And we're going to go to psychiatric history. And this is where you're conducting it, correct?
Yes.
All right. And you indicate in this report, upon inquiry of Ms. Ellis, she stated that she does not believe that she has experienced mental health issues. When asked about psychiatric diagnosis that she has been given, she said that she's been diagnosed with schizophrenia, schizoaffective disorder. So she is having a conversation with you.
Yes.
And she's indicating to you what she believes her diagnosis to be.
Yes, but you'll note the conflicting information between not having mental health issues and then being diagnosed with something.
No, I can appreciate that. But she's talking to you. It's not like there are auditory hallucinations at that time. She's having a conversation with you.
She is able to answer some of my questions.
Okay. And then you go on July 3rd of 2024, when you're there and talking to her with regards to the mental status examination, you indicate that she was initially forthcoming with a variety of disjointed, disorganized information. She became increasingly guarded throughout the interview, answering questions briefly and occasionally with the same response, even if it did not make sense. So where do we get now this guarded throughout the interview?
In that she started declining to respond to questions or would answer with the same response that wasn't necessarily related to the question that I asked.
And I believe Mr. Mack indicated that Mr. Johnson was there with you during the competency.
That's correct.
All right. Is that typical?
No.
All right. So why was it done in this case?
I was concerned about her mental status and seeing her alone.
Okay. And you were at the facility, correct?
Yes.
All right. And there are corrections officers there?
That's correct, but they do not typically stand in the room with me at the time of the evaluation for purposes of privacy.
Okay. All right. But they were there for the competency then?
Outside the room, yes.
The corrections officer, but the attorney was inside the room?
Mr. Johnson was inside the room with us, yes.
Okay. So you come up with the diagnostic impression of schizophrenia?
Yes.
Okay. And again, schizophrenia is what?
A psychotic disorder.
All right. And it's treated with medication?
Correct.
And it's fair to say that there are a lot of folks that have schizophrenia and function very well throughout their lives on medication?
Yes.
All right, we're going to bring in now David Gelman, former prosecutor and defense.
All right, Dr. West did the competency on Bionca when she was taken over to North Coast. I forget the full name of it. But remember, she had her hearing. These pictures are from her arraignment. And she was then taken over and she was given a competency test, if you will. And Dr. West did the competency. So she did meet with Bionca. So please don't please don't spread rumors or let's get factual. If we're going to post things, let's make sure we got our facts right.
It says, during the evaluation, her thoughts were disorganized and she appeared internally stimulated, as evidenced by her looking to the side and smiling to herself on occasion. So, is that an objective observation, doctor, or is that subjective? And how would you know it was an internal stimuli?
I would suggest that the objective portion of that was what I witnessed her doing subjectively. Through my experience, I believed that was related to internal stimulation.
But again, that was a subjective opinion, correct?
Yes, but based on my experience.
So then you determine her not to be incompetent, and then she is sent to North Coast. Fair?
I opined that she was not able to understand the nature and objectives of the proceedings against her and that she was unable to assist in her defense. Ultimately, it was the judge who adjudicated her incompetent, or rather sent her for a 20-day evaluation.
Okay.
So I offered an opinion, and the judge based a decision on that.
So now let's talk about not guilty by reason of insanity, ma'am, right? You've testified, you've said in 5 trials, you've participated in 5 different cases, right?
Yes.
All right. And so I want you to tell this jury your methodology from the beginning to end, what you consider when you are making your determination.
So as we discussed, collateral information is important, historical data, previous mental health records are important. My interview with the individual, the evaluee, is important as well. And if I am conducting an insanity evaluation, I would do so at a time when the individual was relatively symptom-free and able to engage in logical conversation. I would also be interested in other legal history as well.
Okay. And that is all corroborative of determining the wrongfulness of one's actions.
I would use all that information to offer an opinion.
Correct. So all that opinion, all those items are necessary for you to create your opinion, correct?
Yes, they're all pieces of evidence that I would use.
All right. So self-reporting in and of itself is not enough. Would you agree with me?
Yes.
All right. And self-reporting, you would agree with me, should be recorded.
No, not necessarily.
Did you record your interactions in your evaluation for NGRI with Miss Ellis?
In the form of note-taking, but not audio-visual recording.
You did not record her?
That's correct.
Okay. Do you think that that's important to observe her answering your questions and using her own words so that could be related in your report?
I do quote her in my report, and those are based on my notes that I took during the interview.
My question is, do you think that that is important to record an individual and use it in making your determination?
No, I don't think it's necessary to record it.
Okay, why not?
Because I take notes.
Okay, because you take notes, but don't you think it's a fair representation of how the person reacts to your questions when you're asking the question, their gestures, their body language, their ability to understand, their ability not to understand? Don't you think that that is important?
I do, and I'm generally able to observe that during the course of the evaluation.
So you think that just your own subjective note-taking or objective note-taking is enough to demonstrate that?
I do, yes.
Okay, thank you. So in your report, you've indicated all the sources of information. And can you just list those for me, ma'am?
I had obviously an interview with Miss Ellis, my own report relating to her competency, a variety of competency assessments during her time at North Coast, the various police records in a variety of jurisdictions, and outpatient and hospital records from a variety of sources.
All right. And so with regards like to the North Olmsted Police Department records, photos, video footage, and date, do you opine on those in your report?
I don't believe I offer an opinion on them.
And those, some of those videos that were provided to you, you would agree with me, were of the day of the incident.
Yes.
And that is critical in making your determination for not guilty by reason of insanity.
Yes.
So those are objective things that you can look at and make your determination based on your training and your experience, right?
Yes.
All right, we're going to slip in a commercial break. We'll have more from Ohio.
All right, well, while you slip in your commercial break, I'm going to fast forward. What do you think about that, Ted?
Mr. Mack talked to you about the interview. Did you observe her interview?
I did.
All right, at the police department.
Yes.
Again, another objective item for you to consider.
Yes.
And draw opinions from that.
Yes, to the extent of being able to observe her mental status.
Right. You could observe her mental status. You could observe the way she is talking. You can observe her word choices. You can observe her body language. You can observe a lot of things with a video.
Yeah. Yes.
And then you make a determination about it. Fair?
Yes.
All right, so let's turn our attention now, Doctor, to Exhibit K. That is your report, correct?
Yes.
Dated May 14th.
I'm sorry, Your Honor. Dated May 14th, 2025. We want to keep our dates straight here.
Thank you.
All right, Doctor. So let's start with the educational history. Correct?
Yes.
Okay. And in the educational history, she tells you about getting her diploma from ECOT, the Electronic Classroom of Tomorrow?
Yes.
Okay. And she reported that while in high school, she was not placed in any special education classes, and she was described her grades as pretty good.
Ms. Brown. So just read, that's okay, I'm just going to remind everybody. So just reading from that, I asked at a slower pace for the record.
Okay.
Thank you.
Sorry, Rob.
You're okay.
Special education classes, and she described her grades as pretty good, nothing noting that she was an honor student, right?
Yes.
Okay. So you were looking at that because educational history is important, right?
Yes.
And you were looking to see if she had an IEP.
I was.
Right? Can you tell the ladies and gentlemen of the jury what that is?
That is an individualized education plan, often indicating that students were provided special services due to educational needs.
And she didn't need any, did she?
Not according to her report, no.
Okay. And we have no reason not to believe that, right?
That's correct.
No, there was no other collateral information that was provided to you that would indicate that she had an IEP.
Correct.
All right. And she also made it a point to tell you, I think you had in your conversations with Mr. Mack, that she had no guardian and she had no payee.
Yes.
Right?
Correct.
And that is not uncommon for a person who is diagnosed with schizophrenia.
That's not uncommon. I would say payeeship is more common than guardianship. Guardianship is a pretty extensive legal process.
Right, but being your own payee, somebody else doesn't have to monitor their money. They are able to do things with their own money, right?
Yes.
When they are their own payee.
Yes.
Because if somebody else is given that status, then they would have to give, that person could not be able to function or deal with money matters.
That's generally the reason somebody would have a payee, yes.
Okay. But she had neither.
That's what she told me, yes.
Okay. So as Mr. Mack said, you went through then the relationship history, the medical history, the current medications, the psychiatric history, correct?
Yes.
And as you're going through those, you're finding out that she was in the hospital for various things, whether it be psychiatric concerns or some physical concerns.
She did report some physical health issues as well, yes.
And when she went in for physical health concerns, there were times that she was lucid, she was good. There was not one indication of any type of psychotic issue when it was just for health reasons.
I would expect that there would be some medical records that would suggest she was simply there for medical issues, yes.
Right. But because she has a history of it and a diagnosis, right, that would still be part of her file. It would be part of EPIC, right?
It would be listed as a diagnosis in her computer-generated notes, yes.
So when she went to Metro Health on May 24th of 2024, and she was seen for a medical condition, they said that there was no psychiatric issues noted, correct?
Yes, I have no reason to not believe that.
All right. And then let's turn to those Murtis Taylor records. She was frequently going to Murtis Taylor up until about June of 2023.
Yes.
Is that what those are what our documents tell us, right?
Right.
And then we have some Cleveland Clinic records that Mr. Mack went through with you, and it said that the patient, I believe on November 18th of 2015, psychosis and suicidal ideations.
Yes.
And then it says, patient has positive tox screen for THC. Per chart, patient denies drug use.
Yes.
All right. So can you explain to us, how does THC affect the medications that she's on?
I'm not entirely sure she was on medication at this point.
This was in 2015?
Yes.
Okay, fair enough. But obviously she's exhibiting some signs and symptoms of psychosis.
Yes.
Right? So would THC affect that?
It could potentially, yes.
And how would it affect it?
Sometimes THC or marijuana can cause people to increase the number of psychotic symptoms that they have.
Okay.
Let's get a break. We'll get you back into the courtroom for more testimony.
All right, Ted, off you pop, and we'll just keep moving forward. I want to get this testimony in.
All right, on February 24th of 2024, you reviewed some documents from a Dr. Hillman.
Yes.
That would be page 5 of your report.
Yes.
All right. And Mr. Mack read you all about the murder, the El Chapo, all that. And then, but this part wasn't read. No suicidal ideations, homicidal ideations, has been homeless, reports that she is staying in a, it says tent, I'm going to assume that's tent, denies drug use, denies THC use, and he diagnosed her with schizoaffective disorder.
Yes.
All right. And so even after she said all that stuff, or was articulating that stuff, this doctor said there was no suicidal ideations. What would suicidal ideations be?
Thoughts to hurt herself.
And how about homicidal ideations?
Thoughts to hurt others.
So he didn't see any of that.
Yes, that's what he's reflected here.
Okay. And then we move on to North Coast Behavioral. Correct?
Yes.
And you met with her for your interview. What date was your interview, ma'am?
My first interview with Miss Ellis occurred on July 3rd of 2024.
And that was for purposes of competency?
Yes.
Okay. When did you meet her for purposes of sanity?
That was February 19th, I believe. Double check.
Of
Yes.
2025?
Yes.
Okay. So at that time, is it fair to say that now you had more reports from North Coast Behavioral, more observations of how she was acting, correct?
Yes.
Okay. And then you proceed to have your interview with her.
Yes.
Before we go there, and before they make their determination with regards to competency, Miss Ellis has a couple of episodes or incidences at North Coast. Is that fair?
That's correct.
All right. And she assaulted a peer.
Yes.
Okay. And there were 2 incidents of physical assault, correct?
I recall that she assaulted a peer. I know she made some threats. I believe this was documented in Dr. Testa's report. She became aggressive verbally with a nurse as she did not like the color of her cup.
Okay. And at that time, ma'am, was she on medication?
I don't believe she had received medication. That was not until September 23rd. The assault on a peer occurred on September 13th.
Okay, on the peer. but what about the next one?
I believe that may have predated it. I don't have a time or date on the verbal assault of the staff member.
All right. But she didn't like the color of a cup, right?
Yes, that's what's reported.
Okay. And then you go on to family psychiatric history. You talk to her about legal history, correct?
Yes.
And then you talk about this Bakersfield incident, all right? And you indicate that she stated, "What do I need to do to stay in jail?"
Yes.
Is it fair to say, doctor, that she wanted to go to jail?
It appears that way.
Okay. And so she was asking to go to jail because she was being kicked out of an emergency department that she wanted to stay at.
That would be a rational conclusion. I don't know that for certain.
Well, I think you typed a whole bunch of stuff in here, and it says that per the report, the Bakersfield report, Officer Vining reported that on January 26,
Nice and slow.
2024, he was flagged down by Kern Medical for a subject, Miss Ellis, refusing to leave the property. He said that Nurse Paula, P-A-L-A, advised that Miss Ellis was partway through being seen by medical staff, had refused further treatment, failed to leave the property upon being asked by the security, and demanded that the police be called.
Yes.
Nurse Paula stated that Miss Ellis became combative and kicked two of the security guards.
Yes.
Okay? She stated during the assault, Miss Ellis used her right leg to kick Paula one time in the stomach. I then contacted Miss Ellis, who was seated on the floor of the hospital room. When I asked her what was going on, she told me that I needed to take her to jail because she had just assaulted hospital staff. What does that tell us about her?
I guess that she wanted to go to jail.
Okay? And she assaulted somebody because she knew that if she assaulted somebody, she would go to jail. Is that fair?
I think that would be a rational conclusion.
A rational conclusion, right?
Yes.
Because she was able to travel from Cleveland, Ohio to Bakersfield, California. She was able to purchase a ticket. You agree with me?
Yes.
She got herself on a plane.
Yes.
And she traveled to California and brought a suitcase with her.
I don't know about the suitcase to my recollection, but I would agree with those other things, yes.
Okay, that's what typical.
All right, Sky Lazara is still with us.
Ordinary people do when they go on a trip. They pack their belongings, get a ticket, get on a plane, and they get on the plane and they go.
Yes.
Right?
Yes.
Okay. So let's continue here. When I asked her what was going on, hold on a minute here. I lost my place. She stated during the assault, Miss Ellis used her right leg to kick Paula one time in the stomach. I then contacted Miss Ellis, who was seated on the floor of the hospital room. When I asked her what was going on, she told me that I needed to take her to jail because she had just assaulted hospital staff. I subsequently placed her in handcuffs without incident and placed her into the rear of my patrol vehicle. Officer Vining reported that while in the patrol car, Ms. Ellis stated she wished to do something to remain in custody for a minimum of 2 weeks, but would not elaborate as to the reason why. She stated, "What do I need to do to stay at jail?" They conducted a records request, the police, and they found no local warrants or probation, parole status located, no prior contacts. She was determined to live in Cleveland per a located driver's license amongst her personal property. So she was able to bring her personal property with her to identify who she was. She was then transported back to the detention center, okay? And she was charged with battery and trespassing, okay?
Yes.
So she had a very specific plan in that instance. Do you agree with me?
She did appear to want to be in custody, but would not say why.
But she specifically wanted to stay 2 weeks, correct?
Yes, she does mention that.
Okay. So then you continue to look at more police reports and the ones that Mr. Mack went through with you with regards to Bakersfield report here in Cuyahoga County in Cleveland, the North Olmsted. You talk about the Florida one. Again, they're able to take a plane, and you saw there were videos to that one, right? Did you review that video?
I did not look at that video.
Okay. That she was fully dressed in a very nice outfit and was at a very nice hotel, and again had specific plans to want to stay in Florida.
So I'm just going to ask a question as opposed to some of the factual basis that you're placing on the record.
Well, these are all in.
Well, she indicated she didn't see that video. I'm not limiting you. I'm just asking. She didn't see the video, so she can't evaluate it. Sounds like you placed that on the record of what it was. But
all right,
I'll ask you to just continue.
All right, I will withdraw that. So you did not observe the video of that?
I did not.
Okay. All right. Fair enough.
Thank you.
But there was a police report that you reviewed, and you put that she wanted to stay in Florida as well. Is that fair?
Yes.
So then when you look at violence, that would be considered a risk factor. Don't you agree, Doctor?
She did have violent behavior, yes, in early 2024.
All right. And this is all during your meeting on February 19th, correct?
Yes, the information that she reported to me would have been reported to me on February 19th.
All right, and that was 8 months later from the event.
Yes.
Right? And that was pretty much all of her self-reporting.
Yes, I'm generally pretty good about attributing where the information came from.
Okay. And so she is able to speak to you, correct?
Yes.
And you ask her questions because you say that she's oriented, alert to date, time, location.
Is there a question?
I'm getting there, Judge.
Okay.
Thanks.
Sure.
So when you are asked in your report, you describe her mood and stated it was very calm, and you actually used the word serenity.
She used that word, yes.
Oh, so she was very calm and serenity. So can you tell me what she meant by serenity?
I think she was feeling more peaceful than she had before. Moods are typically quotes directly from the evaluee.
And serenity was the word that she used.
Yes.
So she's got a good vocabulary. Would you agree with me?
I agree that that is, yes, indicative of a reasonable mastery of the English language.
Yes. And so then you go through and you start talking about the event. Is that fair?
Yes.
All right. And again, all of these, I have been having some prior experience, a deity's way of believing in things. This is at the bottom of page 9, prior to your diagnostic impression. Dinosaur bones, my astrological signs. Can you give me some context to that?
Oh, yes. My apologies. So this actually is on July 3rd of 2024. We are not speaking of the events of June 3rd, 2024. I'm simply recapping my assessment of her mental status at that time in an effort to contrast it to how she presented on February 19th.
So that is not part of your interview on February 19th?
No, I say Ms. Ellis's presentation during the evaluation on February 2025 differs vastly from her mental status during our initial interview on July 3rd, 2020.
All right, let's get a break. They'll be back at it tomorrow in Ellis, but when we return, we're going to head.
All right, that ends that portion of the stream. All right, now. All right, one good thing is, and I can report this now because we're not giving anything away, because we are on, wait, hold on, is this? Okay, that's what we just watched. Okay, now I'm going to go back to this. Okay, so they have gone home for the day. So they've gone home for the day. They deliberated for 1 hour and 12 minutes. So that's where we stand right now. So we didn't miss the verdict, so all good there. So now we're going to check in on yesterday's, let's see, that was Friday. I guess this was, hold on a sec, I'm getting so confused with this. This was streamed October 13th. So this was streamed yesterday, but they didn't have trial yesterday. I think this was also from Friday's testimony. I'm going to say this was also from Friday's testimony. All right, hold on.
You indicate to this jury that you interviewed Bionca Ellis.
I did.
And did you videotape it?
I did.
And did you use the contents of that videotape to make some determinations?
Well, I used the content of the interview itself that I was, conducting, that was captured on video, yes, to make some conclusions.
Okay. And Doctor, why is it important to videotape the defendant or the suspect that you are talking to?
Well, I don't videotape every criminal defendant, but in this case, there were substantial questions. There were substantial conflicts in the data between the contemporaneous evidence and Dr. West's report. and I wanted to capture that on videotape, my encounter with the defendant, to get her account of the offense, but also to ask her about some of the things that she had told Dr. West and some of Dr. West's conclusions. And so I wanted to preserve that on videotape because I thought it was especially important data.
Okay. And, sir, if I were to show you a couple of clips from your interview, do you want us to go to a certain part of that, or do you want to start with your report and your findings? What, after the interview, what did you do next, and what did you examine?
Yeah, why don't we go through the report?
Okay, fair enough. So, the statement of non-confidentiality, did you have a conversation with Miss Ellis about that?
Yes, that's how we opened the interview, just to get her informed consent. And in that, I informed her of a number of things. That, first of all, that it was being videotaped, and that what she told me was not confidential, that I'd be writing a report, so things she told me could be shared with others, either through my written report or any courtroom testimony. And that although I was a psychiatrist, I would not be her treating psychiatrist, but just doing this one-time interview for the purposes of her insanity defense evaluation. And because of that, then we did not have a doctor-patient relationship.
And did she understand what you were indicating to her and what you were telling her you were going to do?
Yes.
And did she appear to understand, and did she understand?
She appeared to, yes. Yeah.
And did she participate in answering your questions?
Yes.
All right. And what, not because we have a video, but can you just summarize for us your interview with her and what kinds of questions you were looking at? I believe you started off with social history. Why is social history important?
Well, it's part of any standard psychiatric interview to understand the defendant's social history as well as the other various histories that I gathered.
And did she speak about her family?
Yes.
Spoke about her mother?
Yes.
Spoke about her dad?
Yes.
And indicated to you that her dad had some mental illness?
Yes, that her father had schizoaffective disorder.
All right. And she told you about her marital status and things of that sort?
She was single, never married. Yes.
Does she talk about where she lived on June 3rd of 2024?
Yeah, we talked about her travel and then how she had returned to Northeast Ohio, where she had an apartment in Rocky River, but said she was not living in.
All right. And then you inquired about her educational history.
Yes.
And you found out about her background. What did you learn?
That she had attended the Cleveland Public School District, that she was a good student, no major behavioral problems. She left in school in 10th grade, and she told me the reason she left was that she had believed that she had given birth to a large number of children, including that she had given birth to a child at school that had subsequently been taken from her, which I think is just one of her baseline symptoms of her mental illness. But she said that was the reason she left school, was she had bad memories of school because of that so-called memory.
Now, when you say baseline, what do you mean by that?
Well, she's had schizophrenia or schizoaffective disorder for a number of years. And so it looks like that she always, to some extent, has some degree of symptoms and then has periodic exacerbations where her symptoms become worse. So I interpreted her telling me that she had believed that she had something like 15 or 20 children over the years that had all been taken from her as just kind of a chronic delusion that she had.
Okay. All right. Then you talk about occupational history and what did...
Okay, let's pause the doctor's testimony here. Let's see.
All right, so yeah, this is state rebuttal. Thank you guys for pointing that out. I did not watch this live, so I have no idea what this was. So appreciate you guys pointing that out. Let's fast forward here.
And what is that about?
That she had worked in various fast food restaurants. She also had earned a child care certification and had a child care business for a while, watching her aunt's 2 children. And she had also worked as a home health aide. That she had last worked in about 2019, and she had received SSI since about 2017.
Okay. And then you talked to her about her medical history.
Yes.
And does she talk to you about that?
Yes, she said she had hypertension, she had a heart condition called tachycardia, which is just basically a rapid heartbeat. She had adult onset diabetes, sleep apnea, gallstones, uterine fibroids. She had some surgeries in the past for tonsillectomy and appendectomy, low back injury, and then later she told me she had POTS, which is postural orthostatic tachycardia syndrome, so variations in blood pressure and heart rate.
Okay. All right. Did she ever have any type of head trauma or loss of consciousness?
She said no.
All right. Current medications?
When I saw her in June of 25, she was taking Clozaril, which is an antipsychotic medication, and she was also taking medication for blood pressure and for diabetes, and then something called Cogentin, which is it's a medication for side effects of the psychiatric medication.
And you talked to her about some legal history and some travel history, doctor?
Yes.
All right, and why do you talk to her about some legal history?
The question is, why do I?
Yes.
That's just a part of a standard psychiatric evaluation to understand if a person has had prior arrests or not.
Okay. And travel history?
Yes.
All right. You talked to her about that and what she had been doing prior to June 3rd of 2024, correct?
Yes.
All right. And the places she went and the things that she did, correct?
Yes.
All right. Then you talk about abuse history.
Yes.
And what does she tell you about that?
That she believed that she had been abused emotionally as a child when she witnessed her mother and father fighting, which was stressful for her and caused her to be tearful. But she never had been physically abused as a child. She said in 2022 she was assaulted by a woman at Walmart, which she believed was physical abuse. I asked her about sexual abuse, and she said that she believed she had been raped by a family friend, but was uncertain if this was a real memory or simply a symptom of her mental illness.
Okay. And would that be a symptom of her mental illness?
Potentially, yes.
Okay, fair enough. Family psychiatric history important?
Yeah, again, she said her father had been diagnosed with something called schizoaffective disorder, which is a variant between schizophrenia and a mood disorder. Her father had experienced hearing voices telling him to kill himself, and had psychiatric hospitalizations to treat his illness. And there was a question about whether her paternal grandfather also had mental illness, because she said he tended to prognosticate and to make other somewhat strange statements.
Okay. All right. And substance abuse history, is that important?
Sure, that's part of any standard psychiatric evaluation. I took her substance abuse history, and it looked like, although she had used some substances in the past, nothing really close in time to the offense, so it wasn't really relevant.
All right. And then the psychiatric history then. And
Yes.
do you go through that with her?
Yes.
All right. And does she talk to you about the various situations that she found herself in, the various hospitalizations that she was in, inpatient and outpatient, talked to you about Murtis Taylor and going to Murtis Taylor?
Yes.
Okay. And did you verify some of that information through the documentation that was provided to you?
I did, yes. She described to me her various symptoms, which included hallucinations and delusions and depression. She described hospitalizations beginning in 2015 for mental illness and taking medications and outpatient treatment, and that appeared to be corroborated by the medical records which I reviewed.
All right. And then there's a mental status examination on 6/12.
Pausing the testimony right here.
All right, we're going to fast forward. So just to give you an update, this was from Friday. So the state rested, then the defense came on. They only had 2 witnesses, and then now this is rebuttal. And then today was jury instructions and closing arguments, and then they went to verdict watch. And then they have left for the day. So no verdict came in today. They are officially on verdict watch. They deliberated for an hour and 12 minutes. Just so you guys know. So we're playing a little catch up right now.
Examination on 6/12/25. Can you tell me about that, sir?
Sure. It's not really relevant to the sanity evaluation since it's not, it's done a year after the offense, but it's just a way of just describing her mental functioning whenever I interviewed her.
Okay. And just summarizing that, what were your observations of her on 6/12/25?
Well, she was somewhat withdrawn, but she was polite and pleasant. She had good hygiene. Her level of physical activity was a bit reduced. She spoke at a normal rate and pressure at speech, but at a low volume. So I frequently had to either ask her to repeat herself or to repeat her statement back to her. She said she was mildly depressed. She had an emotional blunting, which is characteristic of people with schizophrenia.
What does that mean, emotional blunting?
Just that she didn't display kind of a normal range of emotions, from smiling to sadness when appropriate, but just more flat.
And is that typical of folks that have schizophrenia?
Yes.
All right.
She did report to me things that I believe were likely to be delusional, such as giving birth to multiple people in the past, or multiple babies in the past, but did not have other delusions like paranoia or thinking someone could read her mind. She told me that when I saw her in June 12th of 25, she heard voices talking to her approximately once daily, saying things to her such as, "I'm your child," or "Don't give up." Sometimes the voices didn't make sense, and she occasionally saw the vision of a lion. And the rest of the mental status is me just assessing her for any kind of cognitive deficits like problems with memory or concentration, which she did fine on.
Okay. All right. And so do you also have a conversation about Murtis Taylor?
Well, just that she told me she had been there for outpatient treatment, yes.
All right. So, let's see here. So that's our psychiatric history. We've gone through the mental status. Then you look at police reports prior to 6/3/24. So you look at all the reports that are provided to you.
Yes.
And is there anything of note that you want to share with us before we get to your conclusions at the end?
Sure. So keep in mind, again, these are police reports from the months prior to the offense and in different locations. So we have the January 26, 24 Bakersfield, California police reports, and again, I also watched the body cam videos. So this took place at the Kern Medical Center in Bakersfield, California, where she was arrested. She had refused to leave the medical center property. Nurses told officers that Miss Ellis had...
Can I just jump in, Doctor?
Yes.
So I think the question was, is there anything in the police records that, and we could have it stated, I think you asked him, is there anything that stands out to him?
Yes.
Right. And so I don't know if everything as you're reading it, or is there something specific about the police reports that stand out to you with respect to your evaluation? Otherwise, I'm not stopping him from reading all of them, but I just wondered, was that the right question that I heard? And then maybe it does, maybe all of it does. I don't know.
Well, I was getting to the fact that she had been aggressive, that she had behavioral problems, that she had assaulted hospital staff and refused to leave the property. And in fact, when she was asked to leave the property, she demanded that the police be called. So she was combative, punched the 2 security guards, and she then told officers that they needed to take her to jail because she had just assaulted hospital staff. So I think it's pretty striking behavior that, in fact, she even told officers that she wanted to stay in police custody for a minimum of 2 weeks, and even asked, what do I need to do to stay in jail? And she asked officers how much time she could get for resisting arrest. I think also noteworthy was her bizarre dress. She was wearing pink boots, a skirt, a sweater, and wig. So what was noteworthy to me was that, number one, she's physically violent. Number two, she's demanding that the police be called. And number three, she's seeking to stay in jail, which I think is very unusual.
Well, is it unusual?
Okay, so there's quite a history, as you can see.
All right, fast forwarding through this, just want to get to testimony and not anything else. Okay, now this guy we saw. Okay.
Doctor, if we could, let's turn to page 33 of page 37 of your report. With regards to legal sanity, did you formulate an opinion in this matter, sir?
I did.
And what is your opinion, and what is it based on?
Well, I have opinions on both arms of the legal insanity test.
Okay, so let's start with the first part of the arm.
Yeah. It's my opinion with the reasonable medical certainty that the defendant had the severe mental disease of schizophrenia at the time of the 6/3/24 offense.
And what do you base that on, sir?
Several reasons. First of all, we have the defendant's report to me. She reported a history of schizophrenia or schizoaffective disorder that she had had for many years before the offenses. And the symptoms she reported, including various hallucinations and delusions, fit with the diagnosis of schizophrenia. She also reported that she had been psychiatrically hospitalized and received treatment with antipsychotic and other medications, all kind of consistent with schizophrenia. So that was one part of the reason.
Now, doctor, isn't that just self-reporting?
That's self-reporting, which we don't rely on, but we take it as one piece of data, and then we look for the presence or absence of corroboration, which in this case there was.
Okay, and that's looking at all the records, correct?
The medical records and the statement from her mother, who corroborated that the defendant had schizophrenia. And then, of course, what we know about it, that once it's diagnosed, it tends to be a lifelong illness.
So there is no question that Bionca Ellis has schizophrenia. Can we agree on that?
We agree.
Okay. All right. So your next point then, sir, with regards to your opinion.
It's my opinion with reasonable medical certainty, however, that the defendant did not have a severe mental disease or defect at the time of the June 3rd, 2024 offense that caused her to not know the wrongfulness of the offenses. So despite having schizophrenia, it did not cause her to not know the wrongfulness of the offenses.
All right. Can you explain that now to us, how you have formulated that opinion, sir?
Well, there are several reasons for it, and let me break this down here. First of all, the defendant had a rational motive for the offenses that was unrelated to her severe mental disease of schizophrenia. And there's multiple pieces of evidence that would support that rational motive.
All right, so let's talk about them. What did she tell you?
Well, she told me when I interviewed her on June 12th of this year that her rage caused the stabbings. Rage took control of her to make her do the, quote, wrong thing. She, quote, blanked out, which she further explained, meaning that she experienced rage and anger. She, quote, blanked out and her rage took over. She felt rage and blanked out because before the offense she was hot, dehydrated, had slept outside the previous night, had not eaten that day, and was worried about not having to pay any money and being unable to pay her rent.
Now, doctor, before we go on to B, all those things, some of those are self-report. Don't you need corroboration for that?
There is some corroboration, but I think we can also have higher confidence in motives that people self-report that are not helpful to their case, whereas if they promote a self-serving motive, then we kind of have a reason to question that and look for more corroboration.
Okay. 1B.
We look at the victim and witness accounts of the offense, which whenever I reviewed them indicated that she appeared angry close in time to the offense. So we have witness statements, first of all from Diane Spahar, the Volunteers of America store employee, told officers that Miss Ellis looked angry and distraught as she walked through the store with the knives in her hand. And then secondly, Margaret Wood told officers that the defendant had an evil look on her face during the offenses, which would be consistent with anger and rage.
Well, is it consistent with schizophrenia, sir?
It's independent of schizophrenia.
How so?
It's not a symptom of schizophrenia. Anger and rage, or anger control problems and rage, are not symptoms of schizophrenia.
All right. Then you go on to C and D.
Well, thirdly, when you review the video footage from Giant Eagle and Things Outlet, to me it looks evident that the defendant does appear to be unhappy and walked in an angry, purposeful fashion, and certainly not a disorganized fashion. And then fourthly, if you look at simply the timing and sequence of events, what happened in the minutes, the 20 or so minutes before the offense, it all kinds of lines up why she would be upset. So we know that she was in the North Olmsted police station lobby from 1440 to 1444 hours, seeking to retrieve items she believed had been wrongly taken from her when she had been recently in jail, including cash and a gift card that she valued at $700 that she said she had to have to pay her rent and purchase food and water with. And we know that she was turned away in the lobby because the police officer that handles those complaints was not there that day. And they told her, we don't know anything about your missing items. So she was unsuccessful in her effort to retrieve her missing items from the police station. We then have directly after that, it's all on video, she goes through the parking lot, gets out of her wheelchair, gets rid of her luggage and goes over to Volunteers of America, where she's seen walking through the store, selecting the 2 knives from the Volunteers of America. We have her then, only a few minutes later, entering the Giant Eagle store with 1 knife in hand, and then locating the victims in the Giant Eagle outside by the cash registers there, doing a 180 and turning and walking behind them, following them out, and then committing the offenses at 1,500 hours. So the close relationship in time to the defendant's unsuccessful efforts to retrieve her missing $700 worth of items, the close relationship with that, with getting the knives and then committing the offenses, coupled with her acknowledged rage and anger, to me indicates a causal relationship between her rage and anger and the offenses. In fact, she's still angry about it the next morning when she's interviewed by Detective Jones. She continued to focus on her perception that she had been victimized, that she was missing 700 items, and demanding an investigation and appearing to me to be angry.
Appearing to you to be angry, sir, that's subjective, correct?
It's an observation, but it's, I guess it's open to interpretation, sure.
And was she disorganized in that interview with Detective Jones?
I don't believe so.
And what would you be looking at if she was disorganized in her thought process?
Kind of a word salad, just sentences not making sense, maybe some disorganization in her behavior as well.
But she's focused in that interview.
She's focused on getting back what she believes is her missing items, and then when she's asked about the offense, she simply asks for a lawyer, which appears to be organized.
Okay. And
oh, so this was big. This right here, what we just saw, was the big moment of this doctor's testimony, saying that it was Bionca Ellis's rage that caused the stabbings, not schizophrenia.
All right. Thank you, Julie, for that. Let's see if we can fast forward a little bit here. And yeah, we're going to play jury instructions and then closing arguments tonight. We'll get to them. Ooh, videotapes of the evaluation. All right, cool.
This is the 4th reason why she didn't have the severe mental disease at the time of the offense, which caused her to not know the wrongfulness. There was no psychotic motive which caused her to believe that the offenses were right. And there's different types of motives. There's rational motives, there's psychotic motives, but the defendant still knew that they had done something wrong. And then there's psychotic motives which cause someone to think they're doing the right thing, and only the latter one constitutes insanity. So in this case, there was no psychotic motive which caused her to believe that the offenses were right. Now, she did report to me when I interviewed her on June 12th of this year a number of symptoms. But even if you accept those symptoms at face value as accurate, which, part of them were not corroborated by the contemporaneous evidence, but even if you take them at face value as accurate, none of them would indicate she had a psychotic motive which caused her to believe that the offenses were right. So she reported to me anxiety at the time of the offense, that she was thinking of cutting her arms, this loss of control of her body, visions of herself dying in planets and a black moon, and Satan killing her, visions about, hearing voices telling her to kill herself, feeling like she was overthrown by a monster that was stronger than me, the single voice of Satan telling her to kill herself, the strong presence from the spirits, especially Satan, that stopped her from dropping the second knife. But again, even if you accept that she experienced these symptoms, which again they're not corroborated, but even if you accept them, had she experienced them, they would not have caused her to believe that committing the murders and the other offenses was the right thing to do. So, for example, if she heard voices telling her to kill herself, that would not cause her to believe that it was right to kill the victim. There's simply no connection there. Or feeling that Satan was present, telling her to kill herself, or that she had a loss of control of her body, that would not cause her to believe that it was right to commit the offenses.
But what if she was in a psychosis or disorganization? Her thoughts were all over the place because of her mental illness.
Well, keep in mind the legal test for insanity is not psychosis. It's not disorganization. It's very specific. It's did she have symptoms of a severe mental disease or defect at the time of the offense that caused her to not know the wrongfulness of the offense? So not all psychotic symptoms would meet that test, and certainly thought disorganization would not.
Okay. And you have, I believe, did you hit B and C of number 4, sir?
Yes.
Okay. So number 5 and number 6.
Well, number 5 is I asked her on June 12th, and this is on the video, did you know at the time of the offense that it was against the law to stab other people? And she clearly said yes. She knew that it was illegal.
Okay. And so, Doctor, before we get to a few other opinions, we're going to play just a portion of the video. We're going to start. This is State's Exhibit. I'm sorry. State's Exhibit 204. It is 3 hours in length. But we are going to start, hold on a minute, at 2:23:45.
Do you want me to introduce it first or just play it?
Well, I'm going to ask you as soon as Julian just gets it ready. All right, Doctor, are you in this video?
Right, there's a small cutout there in the bottom left, so I'm there in the extreme bottom left in the white shirt.
And where was this interview conducted, sir?
In this building at the Sheriff's Department.
And who was present for this interview?
Just me and Miss Ellis.
Okay. And is that customary to meet with the suspect by yourself?
Yes.
All right. And so we're going to play at 2:23:45, and we're going to play to 2:57:30.
You're going to play it continuously?
Yes.
2:23 to 2:57.
Yes, that was the agreement that was reached.
24 minutes.
Yes.
Go ahead.
So, Doctor, when you're at this particular point, what point in the interview are you at here?
Right, so we've been talking for 2 hours and 24 minutes. So the first hour and a half, we had gone through the informed consent and all the background histories. And right about 1 hour 50, we started talking about the offense, and that was the rest of the interview. So we had a total about 1 hour and 10. So at this point, we're about half an hour to 40 minutes into it. And so we've already gone over much of the offense already. And I'm going back and asking some clarifying questions. And she's, up to this, she's told me that she blanked out, that something took over control of her body. And so later on, we kind of talk about that in some more detail. But
so again, you're going to play continuously, no discussions, right?
Correct. That was the agreement by the parties.
Okay. Yeah, that's what I thought. Okay, go ahead. Thanks.
So what happened? By accident, So I'm just trying to understand.
You want to pause it for a moment? So, Ms. Mateo, yeah, turn mine up, and let's see if it does it go any hot louder. I can't. Right there. So I put it. Were some of you having problems hearing it? Yes. So this is the maximum. So let's go from here.
So we have to, by accident, you know. So I'm just trying to understand.
The sounds here, the voice of the applications, what made that?
Did you know there was laws against stabbing people at that point?
Yeah.
And everyone knows that. You kiss with that. So you knew it was illegal. Did you have any thoughts that they were going to attack you?
I just heard it was
Or did you, again, my question is, did you have any thoughts that they were going to kill you?
Okay, so this is the videotape of the.
All right, understandably, that's going to be really hard to hear. That's going to be really hard to hear. I don't know if they're going to keep playing it either. We'll see if they keep playing it. Yeah, she's not getting out, you guys. I know you guys have been saying this, that you're just concerned that she's going to be out on the street, and she's never getting out. She's never getting out. She's either going to go to prison and maybe be on meds, probably get in fights with people, probably, maybe be on meds or maybe not be on meds. I don't know. I can't talk to that. Or she's going to go to a facility where she's going to be under constant supervision, going through group therapy, going through one-on-one therapy, making sure her meds are taken, and never getting out. I mean, she's never gonna get out. So I hope that eases your mind. I know a lot of you have said that during the course of this trial. She's not going to get out. She's just not. What she did was horrific and terrible, and she's just never going to get out. The question is, will she spend a life in prison where she may get help? She'll probably end up in fights. She'll probably get picked on. She'll probably fight back. She'll probably maybe even delete somebody there. She may get deleted. Who knows what's going to happen to her? It's either that, or she goes to a facility where she's going to have some kind of care. I think when we did Carlos Dominguez, or no, it was Chloe Driver, I looked up, I think prisons have become a de facto facility, if you will, for people that have mental illness and disorders. It's like 30 or 35%, I think, and maybe in California only. I forget where I was looking. But, think about it. Like 1 out of every 3 people you see in prison is like her, without their meds. Or maybe they're on their meds. I don't know. But she's not getting out. Rest assured, she's not getting out. She's either going to be in prison, possibly being taken care of. I don't know how well they do. Or she's going to be in a facility where they do take care of her and they do, care about her to the point of, making sure she doesn't get in fights, making sure she's, in therapy, talking about what she did, making her realize what she did. So that's where we're at. So she's never getting out. Just leave that, just throw that aside. I know a lot of you have, well, not a lot, but some of you have been saying that over the course of this trial. She's not getting out. There's no way she's going to be let out. That's not even on the table. Not guilty is not on the table. Not guilty by reason of insanity is on the table. But that means she goes straight to a facility. All right, let's get back to this. This is really hard to hear. Unfortunately, it's really hard to hear.
Like a way to express your rage? Were you frustrated? I'm still left trying to kind of make sense of this. Is there anything else you can do to explain this? Is that something that you see as a positive or a negative outcome? Do you know if you're convicted of this?
That's it. All right. All right, Dr. Knopfsinger.
Why don't we take a minute? You want to stand up and stretch your legs, anybody? Readjust. Get you back into it here, please. Sure.
Now, Dr. Knopfsinger, suffice it to say that we just saw, give or take, 20 minutes of that interview. But in fact, that's a 3-hour-long interview that you conduct with Miss Ellis. Is that fair?
Correct. And again, the last hour and a quarter was over the offense, and so this is just the final part of discussing the offense.
Okay. And, sir, with regards to, I believe you mentioned hindsight, and then Dr. West actually mentioned hindsight bias. What does that mean?
Hindsight bias is someone knows the outcome of an event and then form opinions about people's conduct that took place before the event.
Okay.
And it's something we're trying to avoid because you have to place yourself in a person's shoes, what they knew at the time, not having knowledge of the bad outcome, the bad event later.
Okay. And with regards to rational or irrational connections, with regards to your interview with Miss Ellis on June 12th of 2025, was she able to relate to you where she was in her mindset with regard to the incident?
She was ultimately, yes. We had a good hour of her basically not wanting to talk about it, saying, I blanked out, I lost control. And to me that it just doesn't explain the situation. And so I persisted through the course of that hour and pushed back and said, wait a minute, this doesn't make sense. This is not a symptom of schizophrenia to blank out or to lose control. And we finally have there at the conclusion then her, I think, finally saying what really happened, which was that her rage took over. She was angry about her situation, and that was the motive for the offense.
And that's corroborated with the other information that you have in this case.
It's heavily corroborated by, first of all the absence of objective signs of mental illness during the offense, all the video, how she interacted with the police, the witness statements, and the fact, again, that she does look to appear to be angry, and by the offense itself, three stabbings.
3 stab wounds.
Yeah, this is really, really bad what happened to little Julian.
Three stab wounds.
Three actions. Three actions would, to me, be consistent with rage.
And, doctor, therefore, based on a reasonable medical certainty, did you come to your final opinion in this case, sir.
I did.
And what was that opinion?
Well, for all the reasons we've gone over, it's my opinion that at the time of the act, Bionca Ellis had a severe mental disease of schizophrenia, but it did not cause her to not know the wrongfulness of the offenses.
And, sir, just briefly, you know that Dr. West authored a report.
Yes.
Did you review that report prior to preparing your report?
Yes.
And what were your observations with regards to her report?
I have some concerns both about her methodology in doing the assessment and some concerns about her opinions.
All right. So let's talk briefly about the methodology.
Well, first of all, we have only a she didn't number the pages, but I think I counted them, 16-page report.
Correct.
So I think that's a very sparse treatment of a very complex situation involving very serious offenses. I think it did not get the analysis, the full analysis that it deserved. Secondly is that although she lists in her sources of information all the video evidence, she really gives it no consideration in her report. And I would argue that is the most important evidence, the contemporaneous evidence. We have on page 10 and 11 of her report and the first quarter of page 12, her treatment of what she calls the collateral account of the offenses, which is her summary of the police records. So the police records and the video in this case were voluminous, and yet she attempts to summarize it down into 2 pages. She doesn't even say that she didn't do her own analysis of the video. She simply describes the police officer's description of the video, not Dr. West's own interpretation of the video. But even more importantly, in her opinions, she never incorporates all the contemporaneous data into her opinions. She relies heavily on what Ms. Ellis told her. Her self-report made, I believe, 8 months later, that is largely uncorroborated by the contemporaneous evidence. And then finally, there's just holes in her reasoning. She makes an opinion and then attempts to lay out some evidence, but the evidence, in fact, does not support the opinion she's trying to make.
And is it fair to say, Doctor, that in that report, a lot of the evidence that she relies on is the self-reporting of Bionca Ellis?
Exactly. Point 1, she makes 4 subpoints, A, B, C, and D. Every one is Miss Ellis stated, Miss Ellis stated, Miss Ellis said that, Miss Ellis reported. And that's a fundamental error in doing sanity evaluations, is you don't rely solely on what the defendant says. You instead look for corroboration in the contemporaneous data. But then even the points, even if you accept it, at face value is accurate, it still doesn't indicate that the defendant didn't know the wrongfulness of the offense. So 1A is Miss Ellis stated that she was experiencing auditory hallucinations, noting someone's got to die, which made her feel very afraid. Even if she did that, how does that get her to believe that the offenses are right? Secondly, Miss Ellis stated, my brain just snapped. I went blank. I had no control.
All right. And so we're going to see the cross-examination of this.
Okay, so they jumped over to some deceivers. They just do not want to stick around. Hold on, I gotta fast forward through all this other mumbo jumbo. Are we gonna see Cross? You promised us, Julie. Oh, there we go. Promised us Cross. All right, this is pretty good. I'm going to show this.
Could you ever replace my son?
Court TV Crime and Justice correspondent Matt Johnson joins us live with the latest in this trial. And, they're dark today. We have that imposed delay of showing testimony, so we're actually going to catch some of that later this hour. But fill us in.
Yeah, this is probably the most critical part of the trial for this jury. The jury hearing what could be the most important testimony of the entire case, because tomorrow, being day 6, we are right in the center of the battle of the experts. And that's what this comes down to, right? So far, the Ohio jury has heard from 2 forensic psychiatrists, actually 3, who evaluated the defendant, including Dr. Sarah West for the defense and Dr. Stephen Knopfsinger for the state. Let's listen to both.
It's my opinion with reasonable medical certainty, however, that the defendant did not have a severe mental disease or defect at the time of the June 3rd, 2024 offense that caused her to not know the wrongfulness of the offenses. So despite having schizophrenia, it did not cause her to not know the wrongfulness of the offenses.
After that, can you identify what your opinion is?
So ultimately, to summarize, it's my opinion with reasonable medical certainty that Ms. Ellis suffers from a severe mental disease, namely schizophrenia, and was experiencing symptoms at that time related to this illness that caused her to not know what she was doing was wrong.
And really, it comes down to that, right? Because Ellis is claiming not guilty by reason of insanity. The jury is going to have to decide who they believe of these experts as we're in this battle of the experts. And if she understood the wrongfulness of her actions as she was committing this unthinkable crime, that's what they're really deciding. Because the defense has admitted, that she did it. Yeah, there's no argument there.
Yeah, and the video tells it. The jury.
All right, I thought that was an interesting part. Let's see where else they're going. All right, let's see if we get any more testimony. Okay, so that's it for testimony. And then they go over to Donna. All right, so we're going to go now. So that was Friday. Well, they played that yesterday, but that was actually Friday's testimony. But now today's testimony was actually jury instructions and no breaks. Like this was actually live. When I called the newsroom this morning, they said, yeah, no, the judge still has it off. But lo and behold, they actually did have it live. So here we go. Jury instructions followed by closing arguments, and none of the stuff around it, which I'm very, very excited about. So here we go. Looks like no closed captioning, though, which stinks. Good Lord, can they make their... All right. All right, so jury instructions coming up.
All right, thank you. You may be seated. Parties prepared for the closing arguments?
Yes, Your Honor.
Yes, Your
All
Honor.
right, we're here from the state of Ohio. Ms. Patel.
Thank you, Your Honor.
You're welcome.
Good afternoon, ladies and gentlemen of the jury.
Sorry, totally my bad. Totally my bad. Jury instructions. Totally my bad. Jury instructions.
They're live over there?
Well, you got the info. Thanks for the reminder. We can be live. Thank you.
Sure. So for both parties, Anna,
Yeah.
so video's live from here on out,
Oh, it is?
so it's a live stream.
The closing arguments?
Yeah, for this and closing argument.
Judge, after you're done, we're going to have a break.
Correct. You? Or do you want it run off? That might not be the last one. The screen. So again, some of us are better listeners. Sometimes individuals want to read along. You could do so at either of the Mondo pads that we have here as well. Again, once I'm done reading the instructions of law, not specifically your jury deliberations and the law that applies to your deliberations, we'll take a recess for lunch and then come back and allow you an opportunity to hear the closing arguments. Again, you won't have notebooks because it's not evidence, but it is the opinions and the thoughts of each party about the factual basis that came through the witness stand here. And then I'll give you some final charging arguments or instructions to go back. So again, just giving me an opportunity to speak to all of you. Some of the things that I'll share with you are the charges of the court. So members of this jury, now becomes my duty to instruct you on the law that you're going to apply to this case. The very beginning of our time together, I told you that the court and the jury have very separate functions. You're going to decide the disputed facts. I provide the law, which you're going to begin to use when you go back with your deliberations. You're to take this instructions as a whole. The instructions are to be taken and read as a whole. So there are some definitions that I define in maybe the first count that are used in all the other counts, or maybe in some separate counts. So you'll see as I read to you the counts that you will also be using all the instructions as a whole. So you all swore an oath to us, so it's your sworn duty to accept these instructions and to apply the law as I give it to you. This you're required to do apart from any notion or any opinion of any kind which you may have as to what the law is or what the law ought to be. It follows that in strictly keeping with your oath that you refuse to be influenced by considerations such as sympathy or bias or prejudice for or against either the state of Ohio or Miss Ellis in this case. I told you that a criminal case begins with the filing of that indictment that I read to you. It's not evidence. We don't use it other than to inform you. That indictment informed Miss Ellis that she had been charged with a specific number of crimes. It cannot be considered for any purpose whatsoever in your deliberations. You're instructed that the opening statements that you heard and the closing arguments that you'll hear this afternoon do not constitute evidence. You must not speculate as to why I may have sustained an objection to any question or what the answer to such question might have been. And you must not draw any inferences or speculate on the truth of any suggestions included in a question that was not answered. Now, I've defined for you and read for you reasonable doubt, so I'll read it to you again. Every person accused of an offense is presumed innocent until proven guilty by evidence beyond a reasonable doubt. And that burden is on the state of Ohio. So the legislature has defined beyond a reasonable doubt, or reasonable doubt, as follows. Now, reasonable doubt is present when you as jurors, after you have carefully considered and compared all the evidence, that you cannot say that you're firmly convinced of the truth of the charge. Reasonable doubt is doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of the person's own affairs. Now, Ms. Ellis claims an affirmative defense of not guilty by reason of insanity. So insanity, the definition, the plea of not guilty by reason of insanity raises the issue of the insanity of the defendant at the time of the commission of the act. I like to pause and just say, interchangeably, I use the word defendant. Now, obviously, that's Miss Ellis. I show no disrespect to her. The instructions that I give you, I may interchange both Miss Ellis or the defendant. That's just a title given in the legal definition. So I wanted to say that to you and to make sure that it's not anything lesser when I call her Miss Ellis or I call her the defendant. So again, I'll go back to that. The plea of not guilty by reason of insanity raises the issue of the insanity of the defendant at the time of the commission of the act. And defined, to establish the defense of insanity, Ms. Ellis must prove by the greater weight of the evidence that at the time of the offense she did not know, as a result of a severe mental disease or defect, the wrongfulness of her act. Now, a mental disease or defect is severe if it is serious, major, or extremely intense. And I'll reiterate, a person is insane and not responsible for criminal conduct if at the time of her act or acts, A, she had a severe mental disease or defect, and B, as a result, she did not know the wrongfulness of her act or acts. It is the defendant's burden to prove the defense of insanity by a preponderance of the evidence. I gave you that definition as well. So preponderance of the evidence, again, is the greater weight of the evidence. That is evidence that you believe because it outweighs or overbalances in your minds the evidence opposed to it. Now, a preponderance means evidence that is more probable, more persuasive, or of greater probative value. Again, it's the quality of the evidence that must be weighed. Quality may or may not be identical with quantity or the greater number of witnesses. Now, in determining whether or not the defense of insanity has been proved by a preponderance of the evidence, you should consider all the evidence bearing upon that defense, regardless of who produced it. If the weight of that evidence is equally balanced, or if you are unable to determine what side of the defense has that preponderance, then the defendant has not established such defense. If you find that the state failed to prove beyond a reasonable doubt any element of the offenses charged in this indictment, you must find the defendant not guilty. Such a finding of not guilty would complete your duties and you would return a verdict of not guilty. However, if you find that the state proved beyond a reasonable doubt that the defendant did commit the act or acts as charged, you must proceed to determine whether the defendant was insane at the time the act was committed. Again, insanity. The plea of not guilty by reason of insanity, it raises the issue of the insanity of the defendant at the time of the commission of the act. And to establish that defense of insanity, Ms. Ellis must prove by the greater weight of the evidence that at the time of the offense, she did not know, as a result of a severe mental disease or defect, the wrongfulness of her act. It is not a defense that the defendant's reason at the time of the offense was so impaired that she did not have the ability to refrain from doing her act or acts. An act committed under stress or under the stress of motive, impulse, emotion, rage, or passion, however strong and apparently uncontrollable, is not an excuse for an offense by a person not otherwise insane as previously defined here in these instructions. In this case, as in all other cases, again, it's the quality of the evidence that must be given primary consideration by each of you. The quality of that evidence may or may not be commensurate with the quantity of the evidence. That is, the number of witnesses or exhibits that have been presented. Now, whenever reference is made by the parties to evidence on which this case is to be decided, you, the jury, will understand that we mean testimony from the witnesses from this witness chair, exhibits that I've admitted during this trial, and any facts agreed to by the counsel. Now, those facts I've defined to you as stipulations. Just because something has been discussed here at the witness chair or by witnesses here, I may not have allowed the evidence to come in as far as an exhibit. Sometimes lawyers use exhibits to be helpful and they don't offer them. So I'm saying all that to you so when you go back, if you don't have an exhibit that you're looking for, it's not an exhibit being asked for you to consider. You'll use the evidence of the witness's testimony when you do begin to weigh your decision on this case. So again, all the exhibits I will send back with you that I have allowed or that have been offered by the parties. Now, that evidence may either be direct or circumstantial, or it could be a combination of both. Direct evidence is testimony. It's given by a witness who has seen or heard the facts to which that witness has testified. It includes the exhibits that I've accepted as evidence during the trial, and again, the stipulations. That's all known as direct, positive, or eyewitness testimony. Now, it's not always possible to ascertain the truth by evidence of this direct character, and thus the law does permit the introduction and consideration of what is called circumstantial evidence. Now, by circumstantial evidence, we mean proof of certain facts and circumstances from which you as the jury may infer other connected facts, which usually and reasonably follow according to the common experiences of humankind. You are instructed, however, that you are not permitted to base one inference upon another inference. Each inference must be predicated or based upon a proven fact or facts. Two or more inferences may be drawn from the same proven facts, or additional facts and evidence, or circumstances and evidence. In the absence of direct evidence, circumstantial evidence by itself may justify the finding of guilty. Now, I'll give you this example of circumstantial evidence and then kind of tie in inferences on that as well. I know it was discussed just briefly during our voir dire about a factual basis. So you'll hear this factual basis, but I'll go a little bit deeper. So let's assume in the very near future here in Cuyahoga County, you retire to go to bed at night. You look outside, you see the ground is clear. You wake up in the morning, and you find that the ground is covered by a blanket of snow. All right, now you did not see it snow, but from the fact, right, there's a fact that you find a blanket of snow on the ground that day, you have the right to infer, as a circumstance, that it snowed last night. You could also conclude that at some point during the night, it was cold enough to snow, right? So those are two inferences right? You don't know that it got below 32 degrees. You didn't see it snow. But those are two inferences off the one fact, the fact that you see it snow. So you can do that, two inferences off of one fact. However, what you cannot do is from that evidence, you cannot infer that it's going to snow tomorrow, right? That's an inference that's not on a fact. So the law, again, makes no distinction between the weight given to either direct or circumstantial evidence. It only requires that the jury, all of you, after weighing all the evidence, must be convinced of the guilt of the defendant beyond a reasonable doubt. Circumstantial and direct evidence inherently possess the same probative value, and in some instances, as I said, certain facts can only be established by circumstantial evidence. Now, I gave you the credibility of witnesses. We talked a little bit about that definition, so I'll give it to you again. You being the judges of the facts are also looking at the credibility or believability of each witness that came up here and testified. And then you assign the weight of that evidence to those witnesses. To weigh or determine the greater weight of the evidence, you must consider the credibility and the believability of the witnesses who testified in this case. You will use the test of truthfulness that you use in your daily lives. And again, that test. The test includes the appearance of each witness upon the stand, the witness's manner of testifying, the reasonableness of the testimony, the opportunity that that witness had to see, hear, and know those things about which the witness testified, and the witness's accuracy of memory, their frankness or lack of it, their intelligence, their interest and bias, if any, and then together with all the facts and circumstances surrounding the testimony, you then look at the credibility of the witnesses. Use this test and these tests and then assign to each witness testimony such weight as you think is proper for their testimony. Again, I said to you, you are not required to believe the testimony of any witness simply because the witness was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your duty to decide what testimony to believe and what testimony not to believe. The testimony of one witness, if believed by you, is sufficient to prove any disputed fact. Now, Miss Ellis did not testify in this case. And ladies and gentlemen of this jury, it is not necessary that Miss Ellis take the witness stand and testify in her defense. The defendant has a constitutional right not to testify. The fact that she did not testify must not be considered by you for any purpose whatsoever. Now, I've read to you multiple counts, and I'll charge you with each of those counts in a moment. But because there are multiple counts, if you find that the state proved beyond a reasonable doubt all the essential elements of any one or all of the offenses as charged in the indictment, and the defendant failed to prove by a preponderance of the evidence the defense of insanity, your verdict must be guilty according to your findings. And you'll indicate that in your verdict forms. If you find that the state proved beyond a reasonable doubt all the essential elements of any one or all of the offenses as charged in the indictment, and that defendant proved by a preponderance of the evidence the defense of insanity, then you must find the defendant not guilty by reason of insanity according to your findings. And then you'll indicate that in your findings on your verdict form. And if you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of any one or all of the offenses charged in the indictment, your verdict must be not guilty to such offense or offenses. Again, consider each count separately. So the charges set forth in each count in this indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately. And you must state your findings as to each count, uninfluenced by your verdict as to the other count. The defendant may be found guilty or not guilty by reason of insanity, or not guilty of any one or all of the offenses charged. With the exhibits that will go back with you, you'll have the opportunity to use the Mondo pad in the jury room to view any of the evidence that we provide to you that may be video related or pictures as well. And we'll make sure staff shows you how to use that when you go back there. But you will have with you in the jury deliberation room the verdict forms that I'll give to you this afternoon, all the exhibits that have been offered and admitted by myself into evidence during the course of this trial. And during your deliberations, you should know that Rob, as our court reporter, will not be permitted to read back to you any portion of any of this trial testimony. Now, the time that we've indicated to you on the date of the offense and the indictment allegedly occurred has been previously stated for you, and I'll state it again on each count. It is not necessary that the state prove that the offenses were committed on the exact date as charged in the indictment. It is only sufficient to prove that the offenses took place on a date reasonably near the date claimed. So count one of this indictment is aggravated murder under revised code section 2903.01a. And the defendant, Bionca Ellis, is charged with aggravated murder in count one of the indictment. And before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the third day of June of 2024 in Cuyahoga County, Ohio, the defendant, Bionca Ellis, did purposely and with prior calculation and design cause the death of J.W., date of birth 10/29/2020. Purpose. Purpose is an essential element of the crime of aggravated murder. Result. A person acts purposely when it is her specific intention to cause a certain result. It must be established in this case that at the time in question there was present in the mind of the defendant a specific intention to cause the death of J.W., date of birth 10/29/2020. And additionally, purpose is a decision of the mind to do an act with a conscious objective of producing a specific result or engaging in specific conduct. To do an act purposely is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person does an act is known only to herself, unless she expresses it to others or indicates it by her conduct. So how do you determine? The purpose with which a person does an act or brings about a result is determined from the manner in which it is done, the means used, and all the other facts and circumstances and evidence. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose or knowledge. Where an act is a crime, a good motive or purpose is not a defense. Prior calculation and design. It means that the purpose to cause the death was reached by a definite process of reasoning in advance of the homicide, which process of reasoning must have included a mental plan involving studied consideration of the method and the means or the instrument in which to cause the death of another. To constitute or be prior calculation, there must have been sufficient time and opportunity for the planning of an act of homicide. And the circumstances surrounding the homicide must show a scheme designed to carry out the calculated design to cause the death. No definitive period of time must elapse, and no particular amount of consideration must be given. But acting on the spur of the moment, or after momentary consideration of the purpose to cause the death is not sufficient. Causation. Cause is an essential element of the offense of aggravated murder. Cause is an act which directly produces the death of another and without which would not have occurred. And for each count, I will read each of the three options you have. So if you find that the state proved beyond a reasonable doubt all the essential elements of this offense of aggravated murder as charged in count 1 of the indictment, and the defendant failed to prove by a preponderance of the evidence the defense of insanity, then your verdict must be guilty according to your findings, and you'll indicate that in the verdict form. If you find that the state proved beyond a reasonable doubt, again, all the essential elements of the offense of aggravated murder as charged in count 1 of the indictment, and that the defendant proved by a preponderance of the evidence the defense of insanity, then you must find the defendant not guilty by reason of insanity according to your findings. You will then indicate that finding in your verdict form. And if you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of aggravated murder as charged in count 1 of the indictment, then you must find the defendant not guilty and indicate that in your verdict form. Count 2 is murder in the Revised Code section 2903.02a. The defendant, Bionca Ellis, is charged with murder. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on and about the 3rd day of June of 2024 in Cuyahoga County, Ohio, the defendant, Bionca Ellis, did purposely cause the death of JW 10/29/2020. The term purpose I've defined for you, and it's the same definition in this charge in count 2. Cause. The state charges that the act or failure to act of the defendant caused the death of JW 10/29/2020. Cause is an essential element of the offense. Cause is an act or a failure to act which in a natural and continuous sequence directly produces the death of a person, and without which it would not have occurred. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act or failure to act. The defendant's also responsible for the natural and foreseeable consequences or results that follow in the ordinary course of events from the act or the failure to act. There may be one or more causes of an event. However, if a defendant's act or failure to act was one of the cause, then the existence of other causes is not a mere defense. Intervening causes. The defendant is responsible for the natural consequences of the defendant's unlawful act or failure to act, even though death was also caused by the intervening act or failure to act of another person or agency. Independent intervening cause of death. So if the defendant inflicted an injury not likely to produce death, and if the sole and only cause of death was a natural cause or fatal injury inflicted by another person, the defendant who inflicted the original injury is not responsible for the death. And again, in count 2, if you find that the state proved beyond a reasonable doubt all of the essential elements of this offense of murder as charged in count 2 of the indictment, and the defendant failed to prove by a preponderance of the evidence the defense of insanity, then your verdict must be guilty according to your findings and indicated on your verdict form. If you find that the state proved beyond a reasonable doubt, if you find that the state did prove beyond a reasonable doubt all the essential elements of this offense of murder as charged in count 2 of the indictment, and the defendant proved by a preponderance of the evidence the defense of insanity, then you must find the defendant not guilty by reason of insanity according to your findings and indicated in your verdict form. And then the third, if you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of murder as charged in count 2 of the indictment, then you must find the defendant not guilty, and then you'll indicate that in your verdict form. Count 3 is charged in murder in the revised code section of 2903.02b. And before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 3rd day of June of 2024, and in Cuyahoga County, Ohio, the defendant, Bionca Ellis, did cause the death of J.W., date of birth 10/29/2020, as a proximate result of the offender committing or attempting to commit an offense of violence that is a felony of the 1st or 2nd degree, to wit, felonious assault and or endangering children. Again, the term cause has been previously defined and the same applies herein. The underlying offenses in this count are felonious assault and endangering children. The elements of felonious assault I'll define for you in counts 4 and 8. The elements of endangering children I'll define for you in count 5. And those definitions will apply in count 3. And so if you find that the state proved beyond a reasonable doubt, again, all the essential elements of this offense of murder as charged in count 3, then of the indictment, and the defendant failed to prove by a preponderance of the evidence the defense of insanity, then your verdict must be guilty according to your findings. If you find that the state proved beyond a reasonable doubt all of the essential elements of the offense of murder as charged in count 3, and that the defendant proved by a preponderance of the evidence defense of insanity, then you must find the defendant not guilty by reason of insanity. Again, either of those verdicts would be indicated in your verdict form. And then lastly, if you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of murder as charged in count 3 of the indictment, then your verdict you must find the defendant not guilty, and you will then indicate that finding in your verdict form. I indicated count 4 and 8 are both felonious assaults, so I'll read this charge as one, indicating just the differences in 4 and 8. 4 being felonious assault against J.W., 10/29/20, and in count 8, the felonious assault would be against Margaret Wood. So in this count, 290311A1, Miss Ellis is charged with felonious assault in counts 4 and 8. Before you can find the defendant guilty in any one or both of the counts 4 and 8, you must find beyond a reasonable doubt that on or about the 3rd day of June 2024 and in Cuyahoga County, Ohio, Miss Ellis did knowingly cause serious physical harm in count 4 to J.W. and count 8 to Margaret Wood. Again, the cause definition I've defined for you. So here's the definition elements. Knowingly. A person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result or be of a certain nature. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. When knowledge of the existence of a particular fact is an element of an offense, such knowledge is established if a person subjectively believes that there is a high probability of its existence and then fails to make inquiry or acts with a conscious purpose to avoid learning the fact. So how do you determine this? Because you cannot look into the mind of another. So knowledge is determined from all the facts and circumstances and evidence. You'll determine from these facts and circumstances whether there existed at the time in the mind of Bionca Ellis an awareness of the probability that she would cause serious physical harm to J.W. or Margaret Wood. So what is serious physical harm to person? What does that mean? And it would be any of the following. 1, any mental illness or condition of such gravity as would normally require hospitalization or prolonged psychiatric treatment. Number 2, any physical harm which carries a substantial risk of death. Number 3, any physical harm which involves some permanent incapacity, whether partial or total, or which involves some temporary substantial incapacity. Number 4, any physical harm which involves some permanent disfigurement or which involves some temporary serious disfigurement. And then finally, number 5, any physical harm which involves acute pain of such duration as to result in substantial suffering, or which involves any degree of prolonged or intractable pain. Substantial risk means a strong possibility, as contrasted with remote or even a significant possibility, that a certain result may occur or that certain circumstances may exist. And so for these 2 counts, if you find that the state, again, independently each count, proved beyond a reasonable doubt all the essential elements of the offense of felonious assault as charged in any one or both of counts 4 and 8 of the indictment, and that the defendant failed to prove by a preponderance of the evidence the defense of insanity, then your verdict must be guilty according to your findings and placed in your verdict form. Again, for these 2 counts, if you find that the state proved beyond a reasonable doubt all the essential elements of the offense of felonious assault as charged in in any one or both of counts 4 and 8 of the indictment, and that the defendant proved by a preponderance of the evidence the defense of insanity, then you must find the defendant not guilty by reason of insanity according to your findings. And then you'll indicate that in your findings on the verdict form. And if you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of felonious assault as charged in any or one or both of counts 4 and 8 of this indictment, then you must find the defendant not guilty. And you'll indicate that finding on your verdict form. Count 5 is endangering children under Revised Code Section 2919.22b2. As charged in count 5, before you can find Miss Ellis guilty, you must find beyond a reasonable doubt that on or about the 3rd day of June of 2024, and in Cuyahoga County, the defendant, Bionca Ellis, did torture or cruelly abuse JW 10/29/2020, a child under 18 years of age, to wit, 10/29/2020. And furthermore, the violation resulted in serious physical harm to JW. Abuse means any act that causes physical or mental injury that harms or threatens to harm the child's health or welfare. Child means any person under age 18 years of age or mentally or physically handicapped person under 21 years of age. And again, on this count, if you find that the state proved beyond a reasonable doubt all the essential element of the offense of endangering children as charged in count 5 of this indictment, and the defendant failed to prove by a preponderance of the evidence the defense of insanity, then your verdict must be guilty according to your findings. And you'll indicate that on your verdict form. Again, if you find the state proved beyond a reasonable doubt all of these essential elements of the offense of endangering children as charged in count 5, and that the defendant proved by a preponderance of the evidence the defense of insanity, then you must find the defendant not guilty by reason of insanity according to your findings and indicate that on the verdict form. And if you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of endangering children as charged in count 5 of this indictment, then you must find the defendant not guilty, and you'll indicate your finding on the verdict form. There's a further finding on the verdict form which I'll go through with you, and that's the cause substantial risk of serious physical harm. And only if your verdict is guilty of endangering children as charged in count 5, you then must decide beyond a reasonable doubt whether the violation did or did not result in serious physical harm to JW 10/29/2020. If your verdict is not guilty or not guilty by reason of insanity, you will not consider this issue. Again, the term serious physical harm to a person has previously been defined, and that same definition applies herein. And going now to count 6, attempted murder, in Ohio Revised Code section, as noted, 2923.02 and 2903.02a. This charge is count 6, and before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 3rd day of June of 2024, and in Cuyahoga County, Ohio, the defendant Bionca Ellis did attempt to purposely cause the death of Margaret Wood. The terms purpose and cause have been previously defined, and the definitions apply within. So, criminal attempt. A criminal attempt occurs when one purposely or knowingly does or admits or fails to do anything that is an act or omission or failure constituting a substantial step in a course of conduct planned to culminate in her commission of the offense. To constitute a substantial step, the conduct must be strongly corroborative of the actor's criminal purpose or knowledge. Preparation. Preparing, planning, or arranging the means for the commission of the crime does not constitute an attempt. Impossibility. It is not a defense to a charge of attempt that in retrospect the commission of the offense, which was the object of the attempt, was impossible under the circumstances. And if you find the state proved beyond a reasonable doubt all of the essential elements of the offense of attempted murder as charged in count 6 of the indictment, and the defendant failed to prove by a preponderance of the evidence the defense of insanity, your verdict must be guilty according to your findings, and then you'll indicate that in your verdict form. If you find that the state proved beyond a reasonable doubt all the essential elements of the offense of attempted murder as charged in count 6 of the indictment, and the defendant proved by a preponderance of the evidence the defense of insanity, then you must find the defendant not guilty by reason of insanity according to your findings, and place that in your verdict form. And if you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of attempted murder as charged in count 6 of the indictment, then you must find the defendant not guilty, and you'll indicate your findings in the verdict form. All right, 2 additional charges. This one would be the attempted murder charge in count 7. The defendant, Bionca Ellis, is charged as noted in the revised code section. And before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 3rd day of June of 2024, and in Cuyahoga County, Ohio, the defendant, Bionca Ellis, did attempt to cause the death of Margaret Wood as a proximate result of the offender committing or attempting to commit an offense of violence that is a felony of the 1st or 2nd degree, to wit, felonious assault. Again, those revised code sections are 2923.02, 2903.02b. The terms attempt and cause have been previously defined, and the same definitions apply herein. The underlying offense in this count is felonious assault. The elements of that offense I defined for you already in count 4 and 8, and that same definition apply herein. Again, if you find that the state proved beyond a reasonable doubt all the essential elements of the offense of attempted murder as charged in count 7 of the indictment, and the defendant failed to prove by a preponderance of the evidence the defense of insanity, then your verdict must be guilty according to your findings, and you'll then indicate your findings on the verdict form. And if you find the state proved beyond a reasonable doubt all of the essential elements of the offense of attempted murder as charged in count 7 in the indictment, and the defendant proved by a preponderance of the evidence the defense of insanity, then you must find the defendant not guilty by reason of insanity according to your findings and placed in your verdict form. And if you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of attempted murder as charged in count 7 of the indictment, you must find the defendant not guilty, and you will then indicate your findings on the verdict form. And then lastly, count 9, the defendant, Bionca Ellis, is charged with theft in violation of Revised Code Section 2913.02A1. And before you can find her guilty, you must find beyond a reasonable doubt that on or about the 3rd day of June of 2024, and in Cuyahoga County, the defendant, Bionca Ellis, did with purpose to deprive the owner, Volunteers of America store, of property or services, to wit, knives, knowingly obtain or exert control over either the property or services without the consent of the owner or person authorized to give consent. The terms purpose and knowingly have been previously defined, and they apply herein. Deprive means to do any of the following: withhold property of another permanently, or for such period as to appropriate a substantial portion of its value or use, or with purpose to restore it only upon payment of a reward or other consideration. Number 2, dispose of property so as to make it unlikely that the owner will recover it. And number 3, accept, use, or appropriate money, property, or services with purpose not to give proper consideration in return therefor, and without reasonable justification or excuse for not giving proper consideration. An owner means any person other than the defendant who is the owner of, or who has possession or control of, or who has any license or interest in that property or services, even though the ownership or possession, control, or license or interest is unlawful. And then finally, property. Property means any property, real or personal, tangible or intangible, and any interest or license in that property. Property includes, but is not limited to, cable television services, other telecommunication services, telecommunications devices, information services, computers, data, computer software, financial instruments associated with computers. Lots of definitions that don't apply here, but I'll continue to read them. Other documents associated with computers, or copies of documents, whether in machines or human readable forms. Trade secrets, trademarks, copyrights, patents, and properties protected by a trademark. Copyright or patents, financial instruments associated with computers, included but are not limited to checks or drafts or warrants or money orders, notes or indebtedness, certificates of deposits, letters of credit, bills of credit or debit cards, financial transactions, authorizations, transaction authorization mechanisms, marketable securities, or any other computer system representations of any of them. Services include labor, personal services, professional services, rental services, public utility services, common carrier services, and food or drink, transportation, entertainment, and television services. And then finally, consent. Consent may be either expressed or implied. Express consent is determined by the written or spoken words of the persons involved. Implied consent is determined by the facts, circumstances which surround those involved, including their words and acts, from which the jury may infer that consent was given to the defendant. And on this final count, if you find that the state proved beyond a reasonable doubt all the essential elements of the offense of theft as charged in count 9 of the indictment, and the defendant failed to prove by a preponderance of the evidence the defense of insanity, your verdict must be guilty according to your findings. And you'll indicate that in your verdict forms. If you find the state proved beyond a reasonable doubt all the essential elements of the offense of theft as charged in count 9 of the indictment, and the defendant proved by a preponderance of the evidence the defense of insanity, then you must find the defendant not guilty by reason of insanity according to your findings. Finally, if you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of theft as charged in count 9 of the indictment, then your verdict, you then must find the defendant not guilty and indicate that on the findings of your verdict form. And then, ladies and gentlemen, we're going to recess, but here's what I'm going to tell you. I've given you an opportunity to understand the instructions as they apply to all counts that you're going to deliberate on. I'm not charging you to go back and deliberate. So until I charge you with go back and deliberate, that means no discussions regarding this matter with anybody or having discussions outside regarding this matter. So please be mindful of your oath to all of us. With respect to our break, when we come back, again, the lawyers will have an opportunity to tell you what they believe the evidence presented in their closing arguments. Again, it's not evidence, and so I'll not provide you with your notebooks to take any notes as well. And upon finally the completion of those arguments, I'll charge you with a few jury instructions to go back and begin your deliberations. So again, please do not discuss this matter. We'll take an hour break. We'll call through around 1:30, 1:35 to come back up. If we'd all rise for the jury, please.
All right, we are going to zoom through this and get to state's closing argument. So out of the poll we took, has the state met their burden? Yes, Bionca is guilty as charged, 81%. No, Bionca is not guilty by reason of insanity, 19%. All right, so let's get to closing arguments. State goes first. Just so you guys know, state is 30 minutes, and then defense comes in for 45 minutes, and state rebuttal is 20 minutes. So you're at 50 minutes plus 45 minutes, so less than 2 hours. So it's almost 7, 8, 8:30 or so. We'll be streaming until about 8:30 or so. All right, here we go.
All right, thank you. You may be seated. Parties prepared for the closing arguments?
Yes, Your Honor.
We'll hear from the state of Ohio. Ms. Patel.
Thank you, Your Honor.
You're welcome.
Good afternoon, ladies and gentlemen of the jury. I want to thank each and every one of you for your attention and your concern throughout this process. We've been together for many days now, and I know you've been paying good attention to every witness and all the testimony that you've heard. I think we can all agree that it's tragic circumstances that have brought us together. But as Ms. Feralia told you at the outset of her opening statement, it is a privilege to present this case to you on behalf of the state of Ohio. And before you get to deliberate on this matter, I will provide my opening closing argument. Then you'll hear from Mr. Mack and Mr. Johnson, and then you'll hear once again from Ms. Feralia, because the state of Ohio bears the burden, and you'll hear from the state last before you deliberate. Ladies and gentlemen, we are all together today because of the choices Bionca Ellis made on June 3rd of 2024. That day was like any other day in the life of Margaret Wood. And I think we can all relate to what she did that day. Take your kid to the grocery store. It's something that is fun. It's a little get out of the house, buy candy, flowers with your child. And yet, that ordinary act turned into an unfathomable nightmare because of what this defendant chose to do on that day. So what I'm going to do is I'm going to walk us through the indictment, the charges that we have charged Bionca Ellis with, and then we're going to shift our conversation to the affirmative defense that she has raised. All right? So I want to start with count 1, which is aggravated murder. That Bionca did purposely and with prior calculation and design cause the death of Julian Wood. And under Ohio law, the key terms here are prior calculation and design. All right? Those are the words you want to pay attention to when you're deliberating on count 1. What does prior calculation and design mean? Well, you'll have those instructions with you when you deliberate. And in part it says, it's the process of reasoning that must have included a mental plan involving studied consideration of the method and the means, or the instrument with which to cause the death of another. The amount of time that the defendant spends in planning isn't really as critical, but she needs sufficient time and opportunity for the planning of the homicide. So did Bionca Ellis give thought or preparation to choosing the murder weapon in this case? Yeah, she absolutely did. And we can all see it in State's Exhibit 192. And you'll have this, 193. 182, Your Honor, I apologize.
Sure.
Ladies and gentlemen, you will have these videos back with you when you deliberate. I'm going to let this play for just a second, and then we're going to be quiet. I'm going to be quiet for about 50 seconds while we watch Bionca Ellis choose her weapon. "50 seconds. We watch that defendant go directly to the houseware aisles in Volunteers of America, go through that bin, look at the knives, inspect them, handle them, look up top of the knife block up there. She spends almost a minute looking through these knives. She doesn't pick the first one she sees. She finds the two favorites of hers, and then she walks out of the store. She made a decision. That was careful. We spent a lot of time on cross-examination with Dr. Knopfsinger today about how Bionca Ellis didn't just stab anyone in the Volunteers of America store. No, and that supports our argument. This was calculated. She walked out of that store and went to the store next door. Encounters more people on her path. And then when she gets to Giant Eagle, that's when she chooses her victim. But she knew when she chose those knives what she was going to do. She was going to harm someone. She was going to take somebody's life. Now, murder is count 2 and 3, and they're charged under different sections. So count 2 is that Bionca Ellis did purposely cause the death of Julian Wood. And count 3 is that she caused his death as a proximate result of an underlying felony. And what we mean by that is that he died because she committed or attempted to commit felonious assault and or endangering children. And with these charges, there are degrees of culpability and mental states. Okay, so when we're talking about purposely, and again, you'll have all this in your instructions, but these are the definitions of purposely and knowingly. And we're talking about this defendant knowing that her actions would bring about a certain result. Okay, so we know that when she selects that butcher knife and she ultimately stabs 2 people with it, that she's going to bring about a result, right? She's going to hurt them, she's going to kill one of them. And you think about it, with a butcher knife, if you stab somebody, that's going to be the result. You harm or kill. Okay, so when you deliberate these counts, ladies and gentlemen, you can consult your instructions. I'm not going to go through these ad nauseum, okay? I know that you are a smart, attentive jury, but I do want you to pay close attention to count 1 and talk a lot about that prior calculation and design and the plan that Bionca Ellis had that day. And of course, she had no relationship to these people, and that's okay for proving prior calculation and design. You want to focus on the time and the consideration that she spent choosing her weapon and the steps she took after that. Now, we're going to go through the timeline. We have the benefit of really having all of these actions captured on video. So we know that in a couple days prior to June 3rd, Bionca Ellis had a run-in with the North Olmsted Police Department. And that's important because it's part of the anger that fuels her on June 3rd. You heard testimony about how she was in their jail for a night and that she was purported to have all sorts of property and money and gift cards and other items. So when she's walking around on June 3rd, we know that that's on her mind. She says as much herself. But let's walk through this timeline that we have, right? And again, you're going to have these videos, you'll have the compilation video that we went through together. But what I put together today is a kind of a streamlined timeline, all right, so we can see kind of minute by minute where she is. So at 2:36, you see her in that yellow circle. She's in her wheelchair. She's on the North Olmsted Police Department property. A couple minutes later, here she comes into the lobby, and you meet Danielle Shook, one of the first witnesses you heard in this trial. And if you remember how their encounter went, Bionca Ellis wasn't so happy when she left the lobby. Remember, she turned the lights off as she departed the lobby. And then she kind of skips down the stairs. She ditches her wheelchair and her suitcase. And you can look at the video. Again, of course, you heard testimony that she walked with purpose and that she was angry. You can watch that video again that we watched here this afternoon. The careful selection of the weapons, minute by minute here. 14:55, so 2:55, less than 20 minutes after she went to the police station, she's got her weapon. $14.56, she's going to enter the Things outlet. She walks in, looks around. Pay attention. She's got 2 knives still behind her back, and she's looking around. Ladies and gentlemen, she's looking for a victim. These people, they're adults. There's men in the store. Those aren't suitable victims for Bionca Ellis. She's got to find the most helpless victim she can to carry out her crime. She exits. What does she do then? Well, she's got 2 knives. She can't use 2 knives. So she's got to ditch one. She's got to keep the best one. What does she do? She taps her knives against the brick column, ditches the flimsy one, keeps the superior knife to carry out her act. Look at her walk. She's not going into that store for anything but to wreak havoc on somebody that she hasn't chosen yet. And unfortunately, or fortunately, how you want to frame it, again, it's all on video what she does that day. 2:57, there she is, knife in hand. Again, this is 22 minutes have passed since she went to North Olmsted for her money. And here it is. Ladies and gentlemen, this is the decision she makes after she's selected her weapon. These are the people she wants to harm. It's been decided. This is a volitional choice, ladies and gentlemen. This woman is not experiencing, and we'll get there, but this is a woman who has made decision after decision and planned this out. And finally, at 3 o'clock, we know what happens. Now, part of my job here is to make sure that you understand the elements. I'm not going to dwell on this at all, but we know that a child died. To prove that there was a death in this case, we had to show some autopsy photos. All right, I'm not even going to enlarge them on the screen here. You can see these 2 photographs. We know that we have a deceased victim. We also know that Margaret Wood was stabbed and that she was injured, okay, for the attempted murder charges and the felonious assault. She has scarring on her body, and she will always have that scarring. So the state has met its burden as to those counts as well. This case is unique, of course, as we all know, that the burden shifts, right? The state has proved beyond a reasonable doubt all these elements of all the charges against this defendant. Now, there's another step, and you all know it, and you don't have to overthink it. I know it is complex, but at the same time, we want to take it step by step and not overthink what we have to do. So what does it mean that she raised this defense? Well, you know that she has to prove something to you. Has she done that? And how can we tell? Again, I'm not going to read all this stuff. I usually don't put much writing on these slides, but because there is so much to get through, I want you to be prepared for what you'll have to read and talk about in your deliberations. The testimony from Dr. Knopfsinger is pretty fresh in all our minds because he finished his testimony today. The fact that this defendant has schizophrenia does not excuse her for her conduct. So now we are talking about kind of the battle of the experts. Let's talk about Sarah West. All right, you heard from her last week. Her opinions are based almost solely off of this defendant's self-reports. I don't know about you, but I got the sense from her testimony that she either hadn't watched the videos or really did not remember them and did not factor into her analysis of this defendant. You'll have her report to go through. When she was asked about basic things about these videos, She did not seem familiar with them whatsoever. And you've heard from Dr. Knopfsinger how crucial these videos are. This timeline, the methods that this defendant goes through to make her decisions, Dr. West seems to not put much weight in that at all. So that's what I mean by she does not use corroborative evidence from June 3rd. But she agrees with us that June 3rd is the day we're going to focus on. We're not really talking about too much that happened before. We're going to talk a little bit about afterwards, but really June 3rd is what we are really focusing on. Something that struck me about her testimony was that Dr. West said, I see a lot of psychosis here. And I didn't really know what she meant by that because, again, she didn't use corroborative evidence. Not one witness in this trial testified that Bionca Ellis was talking to herself or muttering things, talking to anybody. So Dr. West's suggestion that she was hearing voices didn't make a whole lot of sense to me. And we talked a lot about anger and rage, and that is really the crux of Dr. Knopfsinger's report. And we know that Bionca Ellis was not medicated on June 3rd, but we believe she was very angry, and that motivated her to commit these crimes. But Sarah West doesn't talk about anger. She kind of agrees with us eventually that anger could cause someone to commit a crime. But again, she is not focusing on anything but old medical records and the defendant's responses. Do you remember Dr. West talking about disorganization? That was a big theme of her report and her presentation. And she didn't really define it. And she also said things like, I believe, and maybe so, and probably. Ladies and gentlemen, the preponderance of the evidence is a different burden than the state has to prove when we are proving the elements against this defendant. Think of the tipping of the scales. Okay? It doesn't have to be much of a tip. If you don't believe Sarah West, the defendant has not met her burden in this case. And I submit to you that she has not met that burden. Her theme doesn't make a whole lot of sense. She kept saying that this defendant was disorganized. And I did not find that to be helpful because she didn't really explain it, but Dr. Knopfsinger does. What does he say in his 36-page report where he overturns every video, every record, every interview, and he analyzes it through his expert lens? And again, you can see his report, you can read every word. He talks about what disorganization means. It is word salad. It is gibberish. It's nonsensical. His examples that illustrated this were someone that is loitering or trespassing, doesn't understand what they're really doing. They're kind of aimless. Bionca Ellis isn't aimless, she's angry. She's not disorganized. She's committing a specific willful act. She is not a disorganized person. And Knopfsinger really delves into that for us. So here we are. There's two prongs, as you know. I know you paid good attention in this case. And it's the second prong that we are really focusing on. There is no question this defendant is schizophrenic. That's prong one. Bionca Ellis suffers from a severe mental disease of schizophrenia. However, the fact that she has that diagnosis does not mean that she didn't know what she did was wrong on June 3rd. Pay attention to her interview with Dr. Knopfsinger. Okay? She's not being paranoid. I thought some of the best testimony that made sense to me was about, oh, she's not talking about, there's aliens or there's ghosts or whatever there is. that I'm protecting these people from. There's no delusion. There's no grandiose explanation for what she did. She doesn't think that these people are harming her. Those were examples Knopfsinger used to explain why someone might act the way she did if they truly were insane at the time of that act. We have none of that here. None of that. She is fueled by anger. She is dehydrated. These are her words. You'll watch the video. She's dehydrated. She's hungry. She hasn't slept. It became a perfect storm. Keep in mind, Dr. Knopfsinger has testified for the defense and the state. He's 30 plus years of being a psychiatrist. He has seen a lot of different things come across his desk. He has no interest in the outcome of this case beyond the work that he did, the report he made. He's telling us what is based on his experience, his training, his knowledge. This is not an NGRI defendant, and here's why. Today, he told us that in order to be successful on this affirmative defense, she's got to prove that what she thought, what she did, was right. And she has not explained that in any way. There is no rational motive. I'm sorry, the rational motive that she provides is what we need to focus on. Hungry, dehydrated, missing money, it all comes together. And when she's angry and she sees those people, the relationship, the close relationship in time, that's what we have. That's why we're here. So, ladies and gentlemen, you'll have all the evidence. You can go through all of it. And I know there's a lot. There's body cam and there's interviews. Watch her interview the next day. I want you to do that because she's still very angry the next morning. And I remember we played the interview in court, how loud it got towards the end. You could hardly hear her in the beginning, and then later on, she's shouting, "Stupid people, liars, thieves." And again, the way she acts directly after this. Dr. Knopfsinger pointed it out, and I think the other witnesses explained it as well. She is not saying, "No, don't arrest me. I didn't do anything." She doesn't run away. But she does walk away calmly. She doesn't stay on scene at the car. She succumbs to the officer commands. She never protests her arrest. And Knopfsinger tells us that these are behavioral factors that indicate that she knew she did something wrong. The actions of stabbing. What a personal, gruesome thing to do. And I think on cross-examination, Mr. Johnson talked about, well, wouldn't 30 stab wounds be more indicative of rage? No, ladies and gentlemen, stabbing anybody with anything is an act that would be fueled by anger. To have a 10-inch knife with a 7-inch blade and to select the most helpless victim possible and then stab that victim twice, that is rage. That's what we have in this case. All right, so here we are, at the very end, kind of to recap our timeline. She's upset. She goes directly to the knife houseware aisle in Volunteers of America. and she carries out her crime. Ladies and gentlemen, I urge you to go through all of the evidence together. I know that within your collective memories, 12 of you, some of you may have taken lots of notes, some may have not taken many notes at all. And that's all right. Listen to one another, talk to one another. Go through every video, the reports by the doctors, and discuss. Think but don't overthink. Bionca Ellis is responsible for the death of Julian Wood. And Mr. Mack told you that, if you remember, in his opening statement a week ago. But she did it with prior calculation and design. She knew what she was doing that June afternoon. Hold her accountable for what she did to that child and his mother. She knew what she did was wrong. Find her guilty. Thank you.
Thank you, Ms. Mateo. Mr. Mack, Mr. Johnson?
Please the court.
Thank you.
State of Ohio, members of the jury, good afternoon again. When I first learned of this incident, I learned through the media like a number of you, and I said to myself, what crazy person would kill a 3-year-old child? Those are my words. I said, this world is going to hell. And as fate would have it, I get assigned to the case. And then I began learning about this woman right here. I came to understand that there was mental illness. I came to understand how this came to be. The elephant in the room is this. You have a 3-year-old child whose life was taken from him. Not by his fault, not by his mother's fault. Bionca caused the death of that child. And we all know that this family doesn't deserve this. I implore you to embrace your humanity. It's okay to feel the pain that they're going through. If watching life-saving measures, trying to save a kid's life, if listening to a mother asking if her child is alive doesn't move you, then I question your humanity. If seeing photos of a deceased child, listening to a parent's pain, listening to a mother having to leave out of this courtroom, if that doesn't move you, then I don't know what could. Again, I question your humanity. Knowing that the bail can't be unwound. Because I know a lot of lawyers will tell you, you got to set this aside. You can't set that aside. But guess what? You have an oath. And no matter how much courage it takes or how challenging this is for you, you said during jury selection that you would follow that oath. Now, Mr. Johnson and I, we have to concede that this case emotionally is difficult. I watched you cry during this case. I've been practicing for 31 years. This is one of 3 cases where I felt as you did. That's okay. But you also made a pledge that when you make a decision in this case, it will not be based on sympathy. And you can feel the emotions that you must have experienced during this trial, but still make the correct decision. So, when Ms. Patel tells you that Mr. Mack said in his opening statement that Bionca's responsible, that's true. Even though it's not evidence, that's true. Now I'm telling you in my closing argument that she is responsible for the death of Julian, and you should find her guilty of murder, keeping in mind not guilty by reason of insanity being a defense, and you should find her guilty of the felonious assault as it relates to Margot and a number of the other charges. The aggravated murder and the attempted murder, I'll talk about that later. Look, when this case began, Bionca had options. She could either plead not guilty, she could plead guilty, or she could plead not guilty by reason of insanity. By now you know what she chose. Your job is not to focus on penalty, no matter which side you come down with respect to this. The state's strategy in this case has really been to normalize Bionca. They make the acknowledgement, and they have to concede because they can't get around it, that she's mentally ill. But they want to normalize her behavior on that day. She was in control. She was well organized. Her mind was working separate and apart from her schizophrenia. There was nothing normal about Bionca Ellis on June 3rd. There's nothing normal about her behavior. I want you to look at Bionca Ellis. 1 week from the date of the incident. She's at her arraignment. She's smiling at her arraignment. Even though it's been put forth to her that she could possibly receive the death penalty. Who smiles? Who does that 1 week after this incident? Not someone normal. But guess what? More than a year later, she's medicated now. This is what you've seen throughout the course of the trial. Take a look at it. When someone's medicated, they're confined, their schizophrenia is not active, they're not hallucinating. Those are two different people. But even then, 1 week after, weeks after, months after, her mental illness was still active. It hadn't even ceased by the time that June 10th came around at her arraignment. They want to tell you that Bionca has to tell you what exactly she's hearing in her head. Bionca has to give you this theme that they've come up with that's not even in the diagnostic statistical manual. There's no authority for that. You can believe some, none, or all of what a witness says, even if they're an expert. Even if the narrative is trying to logically make sense. Think about it. And the doctor is mistaken, because I won't say the other word, but he's mistaken. Those are his words, well organized. He says that Bionca was well organized when you look at her behavior on June 3rd. He's the one that introduces rage. I couldn't get up and say it, but if you look at that interview, he introduces this concept of rage. Those are his words. She feeds him back what he's discussing. And if someone is well organized on the date of the incident, She rolls up to the police station in a wheelchair. Eventually she pushes that wheelchair. She has some conversation about money. And then she leaves her wheelchair and her suitcase at the police station. She walks into Volunteers of America. She selects a couple of knives. She walks out. She walks into the next store, Things Outlet, with knives. And then she goes to Giant Eagle. Eventually she sees Margot and Julian, follows them out, and the incident occurs. The state would have you believe that this was all volitional, normal behavior. She goes into Volunteers of America, and she does in fact select 2 knives. Their theory is that this is about her anger about what happened at the police station of not getting her money. She walks into an unauthorized area while in Volunteers of America. She always has the knives out in the open. The first person that she has interaction with is the manager at Volunteers of America, an elderly woman. She doesn't stab her. She walks around the store. She stabs no one in Volunteers of America, and she takes a knife and she walks past the cash register in the open. Both knives. It's not normal behavior. There's something that's going on there. And then she walks into Things Outlet. And the prosecutor would have you believe that, oh, she's hiding knives. If she wanted to hide knives, she could have concealed them underneath her clothing. She has both of her hands on her hips. When you go back there, look at that video. Her hands are on her hips, and she's looking around. Because whatever's happening right here is dictating her behavior. She doesn't see what she's looking for. She comes out, she taps a knife on the pillar, and she loses 1 knife. She walks with the knife in the open, outside. Now, the doctor can talk all he wants about, well, it's crowded inside of the store. We saw how many cars are out there in the parking lot. Bionca can't predict who's getting in and out of their cars. It's crowded, it's in the middle of the day, it's 3 o'clock. And I know you had to pay attention when she's walking with the knife, when she enters the store, and she walks past what appears to be an elderly gentleman, there's a woman coming. None of those people get stabbed, despite her motive being rage. Only when she sees Margot and Julian does she do this U-turn. Now, I want to pause there for a second. Because I'm not going to pretend like I'm a psychiatrist or a psychologist or any kind of doctor for that matter. But you're allowed to use your collective minds, all 12 of you, to try to figure out, based on the evidence, what was going on there. Why is it that Bionca, if she's so upset about her money, why is it taking her so long to stab somebody? We know it doesn't happen at the Volunteers of America. We know it doesn't happen at Things Outlet. We know that she doesn't go back to the police station and take her anger out on the people that wouldn't give her her money. So what's going on? You're allowed to consider whether or not she was hallucinating, whether or not she was experiencing a command hallucination that led her to the sacrifice of the death of the first child that she saw. You're allowed to consider that. And maybe my thought isn't the best about that. But it feels to me like, in her mind, whatever she's hallucinating about, it has something to do with the child. Because she avoids all these other people that she could have taken her rage and her anger out on. steps back and ask you, I just really want you to think about this. Does it make sense for Bionca to be angry about money that she didn't receive from the police department, to seek a 3-year-old child out and stab a 3-year-old child because she was feeling that anger and that rage? Commonsensically, does that make sense? We know that immediately following the incident, she walks away. That's what the state of Ohio's witnesses told you. She walks away as if nothing had occurred, like a walk in the park. And she continues to walk with that knife in hand. And the only time that she puts that knife down is when she's confronted by the police. That's not the behavior of someone who's criminal-minded. I haven't handled any cases like that. Someone walking away from the incident and doesn't put the weapon down and they walk away. Whatever's going on in their head, it is still happening at that moment in time. If you were to take Dr. Knopfsinger's opinion at face value, the only way that she could have been psychotic or having this insane moment would have been for her to stab Julian in the store, sit down right there, don't run, make sure you leave the knife because you don't want to leave fingerprints, and then tell the police or whoever else would listen that she had this experience of wanting to kill a child. It's easy for someone that's been practicing medicine for 30 years to get up here and mislead. Because I guarantee you that what he says should have happened, it's not required in the DSM-5. This very authority that he has to rely upon, there's nowhere that says that you are required, if you're mentally ill, to articulate what you're hallucinating. You can believe some, all, or none of what a witness says. And again, I have to be mindful that you are deeply impacted by the fact that a 3-year-old child lost his life. I get that. That's why she's admitted to the murder of Julian, admitted to the felonious assault of Margot. But you just can't brush not guilty by reason of insanity under the rug because it exists in this case. Even at the police station, she's interviewed for a period of 6 to 7 minutes. Keep in mind that she never says a word to anyone other than the manager at Volunteers of America, when she allegedly asked, "Where's the restroom?" But throughout this whole ordeal, she doesn't have a conversation. In that interview, the detective tries to interview her, and her focus is on the money. And eventually she says, "You can put the Giant Eagle investigation into that investigation." That makes no sense. And when she yells attorney, she's not talking about the Giant Eagle situation. Please watch that interview. She's talking about the money situation. You got to keep in mind that this woman was in jail May 29th. And there's an officer that identified the fact that she's not mentally well. It's just a couple days before this incident. The state has made a concession that there's severe mental disease. They acknowledge that there's schizophrenia. You heard from Dr. Tesla, you heard from Dr. West, that even when they interviewed her, a month later, her psychosis is still active. She's still mentally ill. She's still disorganized, and Dr. West does explain disorganization. Whatever was going on in her head never stopped. And keep in mind that no one ever came here and told you that insanity has to last for 5 minutes, 30 minutes, 2 days. I appreciate the prosecutor coming up here and talking about aggravated murder, but that argument is not a good argument. You don't need me to tell you that there was no prior calculation and design as it related to the death of Julian. You see how random she chose them, and that's at a spur of the moment. And no one can say what was in her head when she was in Volunteers of America. How is she going to tell you what was in her head in Volunteers of America if Dr. Knopfsinger or Dr. West couldn't? Don't fall for that. The reason why I said the attempted murder, is not a good charge because the focus appeared to be always on Julian. Margaret, to her credit, did what any good mother would do. She tried to save Julian's life. Then she got stabbed in the process just one time. If Bionca wanted to murder her, she would have stabbed her several times. And I don't know what world they're living in when it comes to rage. Rage is not 1, 2, or 3 stabs. It's horrific what happened, but that's not rage. It's very important that you understand preponderance of the evidence. Please read that instruction. If it had to be quantified, more probable, the greater weight of the evidence, those are terms that you've heard, but it had to be quantified. It's 51% to 49%. That's our burden. Far less than what they have to prove, which we've conceded to a number of the counts for proof beyond reasonable doubt. You cannot make a decision without considering that burden. I welcome you to have, in one hand, Dr. Knopfsinger's opinion, and in another hand, have Dr. West's opinion, and see which one makes the most sense. You're going to see when you have the jury instructions, you can just focus on me, then I'm going to go to his opinion. You're going to see words in the instruction that talks about, NGRI can't be motivated. So no motive. You know that there's no motive to take the life of Julian in this case. There's never been one established. Even though generally the state doesn't have to prove motive, you have to take into consideration what's in the jury instructions. We know that this wasn't some impulsive behavior. Margot did what she was supposed to do. She took her son to the store, was shopping. She did nothing to provoke Bionca. So there's no emotional response that can be identified through the evidence. There's no impulsive behavior. And again, the word rage is something that Dr. Knopfsinger introduced. We don't agree with that. We don't agree that she demonstrated rage. We agree that her act was wrong. The opinions in this case between both doctors are not equally balanced. You'll see language like that as well. Again, put those opinions side by side. And I guarantee you that if you truly objectively read them, you'll understand that Dr. West speaks of the insanity aspect of this much better than Dr. Knopfsinger does, and it makes more sense. So, in his opinion, pages 35, 36, and 37, and he sort of speaks two ways about this. But on page 35, under 2A, he talks about how Bionca interacted calmly with staff through a window. She did not display any objective signs of her severe mental disease. I don't know how he would be in a position, based on the video that we saw, for him to make that determination. But he thinks that because he's a psychiatrist and his words are powerful, that you're just going to latch on to that, especially with these inflammable facts. He goes on to say in Section B, she not appear distressed or internally stimulated. In Volunteers of America, on the one hand, she's walking with strong purpose, she's got this rage, but she doesn't appear to be distressed. He goes on in Section D, talks about she still does not appear to be distressed, internally stimulated, or out of control. In the Giant Eagle surveillance videos, he says that Bionca was well organized in her actions, did not appear to be internally stimulated, hallucinating, or disinhibited. What's well organized about walking into a store with a knife in your hand, walking with the knife where everyone can see the knife, and just walking around aimlessly until you latch on to those two people? What's well organized about that? Again, in Section E, he talks about how Bionca didn't report symptoms of severe mental disorder, nor display objective signs of severe mental disorder. That's not required. Otherwise, he would have cited that as being authority from the DSM-5. How would he know? And this requirement of her having to report her symptoms, it'd be fine if he identified some authority that they can all agree upon, but you will not see that in his report. We're on to page 36, under 3. He indicates that, and we've talked about this, the defendant approached the victims from behind, which indicates the defendant believed the victims would perceive the offenses were wrong. Again, just look at the totality of the evidence. Look at the knife in hand. When she first walks by them, the knife is not concealed. In Section F, under 3, he talks about how she didn't announce her presence. I just want you to look at all these factors, and you tell me, even commonsensically, if this makes sense. Dr. Nofsinger had the benefit of interviewing Bionca when she's medicated. She's better able to communicate. Never had the ability to interview her early on, like Dr. West. He's got the benefit of incorporating everyone else's reports into his own report, and that's the reason why it's so long, amongst other reasons. Mr. Johnson's going to get up here and he's going to tell you about the not guilty by reason of insanity through Dr. West's eyes. And I would ask that you listen to him. And I appreciate your time. I believe that at the end of the day, she should be found not guilty by reason of insanity. Thank you.
Thank you, Mr. Mack. Mr. Johnson, final thoughts?
May it please the court.
Thank you.
State of Ohio. Ladies and gentlemen of the jury, I too want to thank you because this was a difficult situation, and every last one of you paid close attention to everything that was displayed. You heard from experts, you've seen evidence, and you witnessed the painful details of a tragedy. But make no mistake, we're not denying that this tragedy happened. It's about understanding the mind behind the tragedy. We heard from doctors, psychiatrists. Everyone said something a little different. But you have to use your common sense and judgment. At the end of the day, we have to tell the two doctors, and it has to make sense. The law asks you to determine whether Bionca Ellis, at the time of the offense, was suffering from a severe mental disease or defect, and that renders her incapable of understanding the wrongfulness of her actions. That's the legal standard. Now, Dr. West, Dr. Testa, they both seasoned psychiatrists. They testified through the throes of schizophrenia, paranoid delusions, disconnected from reality. These symptoms weren't new. We learned over the years, she's been going through this time and time again. We have jail logs. She's in different states. Behavior does not change because she's on medication. Now, Dr. Northinger says, well, that's not a part of schizophrenia. But when you look at the evidence, when she's unmedicated, she's not in the right state of mind. You heard from him, 3 people were assaulted in North Coast behavior when she was not on her medication. Dr. Northinger dismissed these symptoms as self-serving. He said he relied on surveillance footage, jail calls. Look at how he interpreted those things. It's through a lens of skepticism. He told you, well, I looked at the video and I didn't see any signs. I didn't see anything where she was talking to herself, but I asked him, I said, well, there's no audio, it's not the best video. How do you know what she's hearing? No, based on the facts, I don't think she has any excuses for her behavior. And the problem with video is, when I slowed it down and showed him a still shot of her in the Things outlet, she was looking up and to the right. Well, that doesn't make sense. If she's going there looking for water, and I asked him, I said, well, water's not going to be up and to the right, is it? Well, no. Well, what if, I asked him, what if she's hearing something and she looks up to see what's talking to her? But he dismissed that. And I think he didn't slow the video down. Videos, when in constant motion, you don't see everything. The illness clouded her judgment. And she did not know the wrongfulness of her actions. Because we heard from Dr. West. She's a seasoned psychiatrist. She spent a lot of time with Bionca. We spent time together with Bionca. And the video you saw her in arraignment, that's the Bionca I met. That's the Bionca that Dr. West met. She wasn't in her right state of mind. But the person you see right here is not the same person. Why? Because she was medicated. Now, Dr. Nossinger said she scurried away from the scene quickly. And I asked him, I said, wait a minute. Let's look at the video. Let's bring it back. He said she rapidly walked away, trying to get away, trying to evade detection. But that doesn't make sense, ladies and gentlemen. She's walking with a bloody knife in her hand. She's not running. Now, you've seen her at the police station. You've seen her. She skipped down the steps rather quickly. So we know she can move at a fast pace if she desires to do so. But that wasn't the case after this. She walked away slowly. Mr. Bush pulled up and said, "Hey, you know you just stabbed that kid." It wasn't a rational answer. Shrugged her shoulders. You had to ask yourself why. What state of mind was she in? She didn't know she just did something wrong. These behaviors are also consistent with psychosis. Individuals suffering from schizophrenia may still follow commands and flee due to paranoia. We heard that from Dr. West. She told you, just because a person's in psychosis don't mean they can't follow instructions. Now, Dr. Nelson said, well, these things are self-reported. He basically said, I take it with a grain of sand, but I didn't believe anything she said. But he said you got to ask her because that's one factor that they look at. Well, she didn't say the right things. He made it appear that there's a playbook of what people with schizophrenia and people who are delusional are supposed to say when they commit a crime. Well, this is not the Browns. There's no playbook. She told him in that interview, you're going to have that interview back there. And she keeps saying over and over and over again, I blinked out. I heard voices. That skeptic eye goes, I don't think so. Not a good enough answer for me. But he said, Dr. Nelson acknowledged that's a key factor, self-reporting. But he didn't listen to her. He didn't take any of it in for his conclusion. He dismissed it. Now keep in mind, he had her longer than most people interrogate suspects. She's in a cold room for 3 hours, no water, no break, and he's pressing her. He's pressing her. Do you think she wasn't tired of sitting there wanting to go? Listen to the video. He introduced rage. He brought it up because he knows it's one of those elements in the law that you're going to read about that you can't use. Mr. Mack talked about the motive. Well, she was angry about this money. The fact that she walked past several people and didn't do anything has to mean something. The fact that when she walked in, she's swinging a knife around. That's not organized behavior. If you're planning to kill someone, you're not walking into Giant Eagle with a big butcher knife swinging, because it screams out, hello, what's going on? The sad thing is, no one in Giant Eagle even paid attention. I don't know if it was trying to avoid looking at her, trying to act like she wasn't there. She walked around with a butcher knife, and I'm thinking, who can walk through a store with a butcher knife and not the police not be called? The police are less than 2 minutes away. I'm thinking, did Volunteers of America have loss prevention? She walked right past the cashiers and not even stopped to pay. No one called the police and said, hey, this lady just stole the butcher knife. So when you talk about this timeline, this is a sad sequence of events that somehow it could have been prevented, but it wasn't. So we're stuck with what happened. And what happened was a tragedy. And it wasn't because she wanted to kill someone. It wasn't because she set out that day to kill someone. She told you, and you're going to hear in the video, she goes, I didn't think I would throw my life away like this. I had other plans. I didn't think I would throw my life away like this because I had other plans. She wanted to move to Florida. She talked about Disney. I put in applications for Disney. Dr. West states in her opinion, with reasonable medical certainty, that at the time of the events on 6/23/2024, Ms. Ellis was suffering from severe mental disease, schizophrenia. That's just one problem. We know that because everyone talked about the one problem. We know for 10 years she was schizophrenic. But what Dr. West did was listen to Bionca. She listened to her rationale behind what she did. She listened to her about saying there's voices. She talked about the suicide. You're going to hear all this. You're going to have both. You're going to have both reports there. You got to use your common sense and judgment and say which one makes more sense. A lot of the reasons that Dr. Nelson put out there, it didn't make sense. It didn't make sense. No one was trying to hide. No one was trying to run. He goes, well, when she got apprehended, she didn't say the devil made me do it. She didn't say anything. That's a part of her disorganized thinking. When she got to the room the next day with Detective Jones, her mind was on, where's this debit card? Where's this money that they took from me? He cannot say with a degree of certainty that he knows what she heard or didn't hear. Because when you look at that still shot that's in our photos, she's looking up to the right. Something has her attention. She's not looking straight ahead. She's not trying to hide the knife. He said she's hiding the knife. And like Mr. Mack said, it was behind her back. Her hands were on her hips. The knife was in her hands. Listen closely at her interview. Because she explains away everything, what she was thinking. But when she gets pushed, when she hears those words, well, I'm about to give you some pushback. She listened to the authority. She let him push back. At the end, and you're going to have Dr. West's opinion, she opined with reasonable medical certainty that the time of the incident, 6/3/24, Miss Ellis had a severe mental disease, schizophrenia, and it caused her not to know what she was doing was wrong. Ladies and gentlemen, based on those facts, everything that you heard here today, you have no choice, and we'd ask you to find her not guilty by reason of insanity. Thank you.
Johnson, thank you. Lastly, Ms. Morelli, I will hear from the state.
Counsel for the state, Detective Ventris. Counsel for the defense, Defendant Ellis. May it please this court.
Thank you.
Good afternoon, ladies and gentlemen of the jury. Our journey of the last week and a half is coming to an end. Our jobs as advocates in this case are coming to an end. And make no mistake about it, folks. We are advocates for each of our sides. But your job is just beginning. Though you have toiled with us for the past week and a half, you have traveled to this courtroom every single day. You have listened attentively. You have taken notes, some of you more than others. And at times, there was a bit of levity. But just because there was a bit of levity does not mean that this case isn't serious. One member of our community died on June 3rd of 2024, and that was 3-year-old Julian Wood. His mother, Margaret Wood, was stabbed, and she survived at the hands of defendant Bionca Ellis. You know, folks, everyone has thanked you, each of you, for your time and your energy and for your effort that you've given us. We've imposed on you folks, and you have made the sacrifice in your personal lives for us. And your sacrifice isn't over yet. After I'm done speaking, the judge will continue to give you some further instructions, and then the case is going to be given to you, and it will be in your hands for deliberation. You don't have notebooks at this particular junction because, as you already know, opening statements and closing arguments are what we think, what we believe, not what you heard from that witness stand. If I say something in closing argument, or for that fact, an opening statement that you didn't like or you didn't agree with, you rely on your 12 collective memories, because that's what our jury system is about. It's about you and what you hear in this courtroom to make a determination between the state of Ohio and this defendant, Bionca Ellis. I am going to share just a few things with you that I saw and that I heard in this courtroom. And by no means am I here to misrepresent anything. I want you to rely on your 12 collective memories. Some of you have taken copious notes. What have you seen in this courtroom? What testimony have you heard? This courtroom has been your oyster for the past week and a half. You can believe some, all, or none of what has been testified to. That is your prerogative. You are the sole judges of credibility. I want you to use your common sense and your good judgment that you use in your everyday life to make a decision in this case. And I know that you will make a decision in this case. In opening statements, I told you folks to pay close attention to Bionca Ellis's actions. Mrs. Pateo stated in her closing argument this afternoon that the defendant Bionca Ellis killed Julian Wood and attempted to kill Margaret Wood on June 3rd of 2024. We told you from the beginning that the one principal issue in this case is not going to be who did it or whether she did it. It's the issue of legal insanity. What that encompasses, folks, is that this defendant, with a plea of not guilty by reason of insanity, is asking you folks to relieve her of her responsibility of accountability for the death of Julian Wood and the attempted murder of Margaret Wood. If the state proves all the elements beyond a reasonable doubt, she's saying, hold on, folks. I was legally insane, therefore should not be held responsible. But you folks recall that the burden is their burden to prove those two elements of legal insanity by a preponderance of the evidence. That scale has to tip. If it doesn't tip, they can't have it. One prong is not good enough. You need to focus on both prongs of the test that have to be met. If you do not have the second prong, she is guilty of each and every count. You heard the defense tell you, yeah, she's guilty of the murder, folks, but not guilty because of reason of insanity. They don't have the aggravated murder. We have the video. You decide. You decide how she acted that day. And was she hearing voices? And by no means am I disparaging anybody's mental illness here. I want you all to believe me from the bottom of my heart, because there are folks that walk around us each and every day with mental illness, and they don't kill people. What were her actions that day? You evaluate those actions on June 3rd, 2024, because that's what the law says. No one is disputing that she has been diagnosed with schizophrenia since she was 19. Not Dr. Nossinger, not Dr. West. Nobody's disputing that. But the issue becomes, did it affect her so much that she did not appreciate the fact that she stabbed a 3-year-old twice and a woman once? I submit to you, she knew exactly what she was doing. And it took her 8 months to come out with, I was blanking out, I was hot. I'm not diminishing her illness, but keep in mind, the excuses came 8 months later. Look at her actions in Volunteers of America. You know, I think in this courtroom, folks, for the last week and a half, we've been playing semantics. Tossing, throwing, dropping. You decide. You decide what she did that day, because you get to watch her as she's picking out knives. She's looking at the knives. Which knife is better for me? This isn't something I made up. I didn't go out and choose that Bionca Ellis was going to be the next defendant that I prosecuted in my tenure at the prosecutor's office, which has been long. And I didn't pick the Wood family to be the victims of this case. I get assigned cases because defendants bring themselves into this courtroom. So you have the two knives. We can agree on that because we have video. So there's not much dispute about the video, because then it becomes interpretation. Interpretation by the state, interpretation by the defense. At the end of the day, the only interpretation that is important is yours. What do you see on those videos? Because if we didn't have the videos, then that would be a different ball game. But we have the videos. You have her actions. When she goes in to Things Outlet, the knives are on her back. Yes, she's positioned like this, but the knives aren't swinging here at Things Outlet. She is looking around to see who she's going to pick on. She goes outside. She stabs a column to see the pliability of a knife. That is somebody who wants a good weapon. That's not somebody who's just hitting the column. And then she goes inside of Giant Eagle. And you determine, because she's thinking about it, it's like hunting, calculated, manipulative. She goes in and sees a child in a cart that can't get out of a cart because his legs are coming out, and a mother pushing it. As soon as she sees them, that about face is so quick and follows them. But then she's too fast for them. So what does she do? She holds back and waits for her prey to continue to move on, and then she follows right along. There's nothing disorganized about that. That is focused. That is laser focused, ladies and gentlemen. And then she goes into the parking lot. And you heard Mr. Stroud and you heard Mr. Bush. They have no stake in the game. They told you what they saw. Never was she talking to herself. Never was she mumbling. Yet she took a knife and she plunged it into the back of a 3-year-old. That's what they did see, standing over her. Over him, I'm sorry. You heard the medical examiner. She's got no stake in the game. She told you that that butcher knife went into that child's body 4 inches that severed the carotid and 4 inches that stabbed the lung. She walks away nonchalantly. She walks away not in the aisle that she committed the crime, the next aisle, and she walked with a bloody knife. When the police arrive, she follows commands. And during the interview on June 4th, she talks to Marjorie Jones. You, ladies and gentlemen, have to watch that video. And what do you see? What do you see in that video? And where is her focus? I disagree with Mr. Mack. When he says that Dr. West talks about this disorganization that she had. I thought she was pretty gosh darn organized about what she was doing that afternoon. And you know what, folks? Dr. West said that self-reporting is not enough because she co-wrote an article with Dr. Knopfsinger, who's been practicing for 30 years. And make no mistake about it, folks, he doesn't have a stake in the game either, because he's testified for the state, for the court, and for the prosecution. He is a professional. And when you compare reports, it's not about how many pages it is. It's about the methodology. And you heard her. She agreed with me. Methodology is very important. Finding corroboration objectively is important. You decide, ladies and gentlemen. The defense wants you to believe that I want to normalize Bionca Ellis. I don't want to normalize anybody. Her actions normalize herself. Because like I said before, many people in our country suffer with mental illness every single day. But they don't go out and murder people. No one is going to stand before you and tell you that Bionca Ellis is not a schizophrenic. I'm not here to tell you that. She is. She was her own payee. She was living her own life, doing her own thing. Going to California, going to Florida, functioning herself. Nobody had a guardianship over her. You heard that. But on June 3rd, 2024, Bionca Ellis killed Julian Wood and stabbed the mother. It was aggravated murder all day, every day. The murder and the felonious assault, yes, somebody got hurt and then they died. That's murder. You have the interview of the 4th. You have all the body cams, all the videos. You have both reports. Ladies and gentlemen, at the end of the day, ladies and gentlemen, as this case is winding down, we recognize in a civilized society that we rely upon the recourse of the law. We owe it from one generation to the next. The recourse of the law requires that you find the truth. In finding the truth, it really requires that you have faith in yourselves and faith in the law. What your decision is in this case completes the accounting for the death of Julian Wood and the attempted murder of Margaret Wood. You've been on this journey with us, folks. The recourse of the law instills in all of us responsibility. And we don't lose that responsibility by claiming that we were insane at the time. That balance is off, folks. If they don't meet their burden of proof, not guilty by reason of insanity does not exist, and you find her guilty of each and every count of this indictment. And I ask you that. I ask you that for our community and for the mental health community. Because good people sometimes make really bad choices, but they know what they're doing. Thank you.
Thank you. Ms. Rowley, do you mind taking that? Thank you.
I'm sorry.
Oh, thank you. Just equal to the other. All right, so ladies and gentlemen, I'm going to now charge you with your instructions to go back and begin your deliberations. Because this is a criminal case, the law requires that all 12 of you be in agreement before you can consider that you've reached a verdict. For the 12 of you, one of you will be picked as a foreperson. I'll talk about that in a moment, but each of the jury instructions are redlined. These are the originals that need to be returned to me as the court. We'll give you an envelope to seal them in so that you can give them back to the court. I'll talk a little bit about the directions. So whoever the foreperson is, there are a couple things that I'll advise you of regarding your choice as foreperson. But before we even get there, You have heard some discussion about punishment, and that may have come in different ways. I don't think any of the lawyers brought that up, or any of the witnesses who maybe have brought it up as well, in any way to diminish my responsibility. But you may not discuss or consider the subject of punishment at all. It is only your duty to carefully weigh the evidence, decide all those disputed questions of fact that came through this witness chair, apply the instructions that each of you will have to your findings, and then render your verdict accordingly when you return the verdict forms. For the 12 of you, your verdict and efforts must be to arrive at a just verdict, right? Considering all the evidence, and then make your findings, and do that with intelligence, impartiality, without any bias, without any sympathy, without any prejudice for or against the state of Ohio or Miss Ellis. Both parties come here, both the state of Ohio and Miss Ellis, both of them come here and believe that they will leave here feeling that their case was fairly and impartially tried by all of you. When you do go back to the jury room, upon your retirement, you will immediately proceed to select one of your number as the foreperson. That person will preside over your deliberations. Whoever that foreperson is, you're sitting in this room right now, hear me. You have no greater authority or power over any other member of this jury, except I'm charging you as the foreperson with the responsibility of ensuring that each of the jurors is given an opportunity to express their opinion on the evidence. Of course, the foreperson, when you've reached a verdict, you're all going to sign this and make sure that as the foreperson they're filled out correctly. Doesn't matter what order you sign, there's 12 signatures. Doesn't matter that you have to sign in the same number or the same place, but just when you've reached a verdict, you'll sign the verdict form in ink, which agrees to the finding that all 12 of you have. Now, if you have a question about these instructions that I give you, it has to be discussed between the 12 of you first in the privacy of the jury room. If all of you disagree, or some of you disagree as to the meaning of the instructions, it may be possible, under certain conditions, to review those matters by a request to myself. Know this. If you ask a question of the court, I convene all the parties first. We have a discussion about the question. We may bring you back in here and have that discussion about your question here on the record. I may provide you something in writing. If I've provided it to you in writing, it's because the parties have discussed it. But just know that you send a question to me, it's not going to be answered immediately because I'm going to bring everybody back in for discussion about your question. But whoever the foreperson is, please write or print neatly, sign the question. That question is part of the evidence and stays part of the case. So once you sign it, date it, and we'll have the case number on it, and write me your question. We'll make sure we get it answered for you. If you desire to address any communication, again, as the foreperson, you must reduce it to writing, have it signed by the foreperson. And the question, again, is usually answered here in open court. And if I do give you something in writing, save the question and answer with the evidence. Again, after you've reached that verdict, you'll contact this room through Kathleen, and then your verdict will be read here in open court. After the verdict is returned, then you're discharged as jurors. Then you can discuss this case with anyone or not as you choose. But until a verdict has been returned here in open court, you may not discuss this case with anyone or let anyone discuss it with you. I'd like to go even like a step further. 11 of you are in the room. 1 of you is in the restroom. There's no discussion, right? You're not discussing the case when everyone is not present. So I give that distinction because it's very important that all 12 of you are present. Now, as alternate jurors, I am going to excuse you from the deliberation process as alternate jurors. When we recess, I'd ask that there be no discussions in that jury room until my 4 alternates have gathered their information or their stuff from the jury room and have exited the jury room. So you are not picking your foreperson until the 4 alternates leave. But for 4 of you, you still remain part of my jury. There is enough times in my career as a judge that there's a possibility that juror 1 has to step in for someone who's unable to fulfill their duties as a juror. So you're instructed for the 4 of you not to discuss this case with anyone. You're not to discuss what your verdict might have been or discuss anything about this case. When there is a verdict, we bring you back up into my courtroom so that you're part of hearing that verdict read. And then, of course, there are discussions that you can be part of afterwards. So when we're done here, I ask that you grab your belongings from the jury room. Ashley will bring you downstairs. We will have you down on the 4th floor, but we also take your phone numbers just to make sure that we put you on a group text and let you know what's going on when you need to come up. So again, grab your stuff and then leave. Again, you're still part of this jury. No discussions at all as we move forward. For the 12 of you, look, the law in constituting a jury of 12 jurors, it contemplates that each of you, all 12 of you, give your individual consideration to and upon the judgment in this case that you're going to render. It gives your individual consideration upon the evidence that came through this witness chair. The rules of law which are explained to you here in these jury instructions are binding upon each of your individual conscience and the judgment as members of this jury. While deliberating, please, each of you jurors should give careful consideration to the views which your fellow jurors have, even if it's not your decision or your thought process. A juror should not turn a deaf ear to their associate jurors. And then without listening to their reasons or their arguments, you obstinately stand upon your own opinion, regardless of what may be said by another juror or jurors. It must be the object of all of you to arrive at a common conclusion, and to that end, you should deliberate together with calmness, in a dispassionate manner, being considerate of each other's views. You should really have 2 propositions of equal importance in mind when you're deliberating. First, that the laws here are enacted for the benefit of all members of organized society. And when you as a jury are convinced beyond a reasonable doubt of a defendant's guilt, then you as a jury should say so in its verdict. And then moving to the second prong if you need to. Again, as a jury, being convinced by a preponderance of the evidence, you should say so in your verdict form if you find that. And secondly, that no defendant should be convicted of a crime when you, the jury, are not convinced of such defendant's guilt by evidence beyond a reasonable doubt. The verdict that you as a body reach is of your own. There is no right or wrong verdict as long as you've considered all the evidence that came from this witness chair. That you listen and follow the law that I give you, and as I have instructed you here this afternoon. And so I say to the 12 of you, ladies and gentlemen, this case is now in your hands for a verdict. If we'd all rise, please. We can be seated. I see counsel at sidebar.
All right, I think that's pretty much it, but let me just fast forward just to make sure we don't miss anything.
The record, again, as I thanked you at sidebar for your professionalism, all of you represent the law well. As a judge, we all hold the same professional degree, and I appreciate your respect for our degrees and for the professionalism in the courtroom. So thank you for this almost 2-week process that we've been at. That being said, I've given you an opportunity to review the jury instructions, and so as I read them, of course, I read them as as correct as I can. And so I just want to know if there were any objections to those jury instructions from the state of Ohio that I've shared with the jury today.
No objections, Your Honor.
And on behalf of Ms. Ellis.
No, Your Honor.
All right, very good. I know we all have your numbers. I know you all have busy schedules. You're going to be going somewhere else starting tomorrow, if not in 5 minutes, to some other courtroom. But at least remain in contact with Kathleen so that if we have a question or we have a verdict, that we can reach all the parties as well. Anything further then before we recess? State?
No, Your Honor. Thank you.
Thank you. Anything from the defense?
Just I'll go back to the sidebar, Judge.
All right, very good. Then we'll adjourn with respect to the case. Thank you.
All right. Now, as promised, Kimbers went to the Volunteers of America and took some video. So let's get to that. And just so you know, the jury deliberated for an hour and 12 minutes and 19 seconds. And then they went home. All right. So let me get this queued up. Let me see. I'm not quite sure how this is going to work. Let me try this. Hold on a sec. Hold on a sec. How can I do this? Because it's not in YouTube. Hold on. All right, I got to figure out how to do this because it's not an image. It's not in YouTube. Audio input capture. No, it's not audio. Chris, wake up. Pay attention. Video capture. Let's see. I don't think I've ever done this before. Meaning I think it's always been from YouTube. All right, hold on. Let's see. I hope I don't go away. No, that's not right. Excuse me, that's not right. Hold on. I don't know if I know how to show a video. All right, bear with me. Media source. Okay, this may work. All right, this is going to work. It's been a long day. I need to eat some food too. All right, here we go. Got it. All right. Now.
Okay, Chris, I'm filming me walking in just in case they won't let me take pictures. You know that.
Hold on. Transform it. That way? Okay. All right, now. Okay. So this is from Kimbers. Excuse me, this is from Kimbers. Let's rewind this. So what Kimbers says is, let's see. Kimbers says, so I had the cashier woman show me where the silverware was located because it wasn't out anywhere, and you will see that they are now in baggies. And she told me they don't have the knives out anymore due to Bionca Ellis, and I played dumb like I had no idea what she was talking about. So this is Kimbers walking into.
I'm filming me walking in just in case they won't let me take pictures. You know that I really tried.
All right, awesome. That's Kimbers walking in. Did you get a release from that person walking by? We'll have to like blur them out so they don't come at us. All right, so that's Kimbers walking in. And now here's Kimbers at. All right, let's check this out.
They don't have them laying out anymore. They have them in these bags. You see these bags full of utensils, and there's no knives out here except for butter knives. Like butter knives. They don't have them laying out anymore. They have them in these bags. You see these bags full of utensils, and there's no knives out here except for butter knives. Like butter knives.
All right, so they're in utensils and they have them out. They just have butter knives out.
They don't have them laying out anymore. They have them in these bags.
So that's interesting.
They're in these bags.
They're in bags. So, and they don't have knives anymore. They just have utensils, regular, spoons, right? Spoons and forks, and then they have butter knives.
Full of utensils, and there's no knives out here except for butter knives. Like butter knives.
Okay, so there's a butter knife. I see. All right. Very cool, Kimbers. All right, round of applause for Kimbers. Woo! Whoop, 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 whoop. That's awesome. Good job. Fantastic, Kimbers. Way to go. Points to Kimbers. Hold on, let me type it. Hold on. Awesome, awesome, awesome. Way to go, Kimbers. Way to go. Thank you so much. Yes, great work. Great, great work. You're trying so hard to be discreet. That was awesome. Thank you. All right, cool. I love it. I love it when our chat is at a trial, or in the area and can do things like that. That's so cool. So appreciate that. And you didn't get arrested. So there. Although you were caught on surveillance, I'm sure. Just in case anything happens, somebody comes knocking at your door 6 months from now. Kimbers from Ohio, were you at Volunteers of America on October 14th, 2025? Oh, wait. The cashier was a gossip girl? That's funny. That's funny. Yes, good work, Kimbers. Thank you, Kimbers. Everybody's giving you yes. 3 rounds. Cheers, cheers. Woo! All right. Right on, guys. Right on. All right. I think that might be it for me. It's been a long day. So, I shall say good night as well. Oh, before I go though, guess who this is? Can you see who that? Can you see? Can you make this out? Little paws. Oof. Little heads over there. That's a little head over there. A little paw over here. That's Sid. That's Sid. I'm pretty sure that's Sid. Oh, no, that's Riker. Sid's back there. Oh. Yeah, so that's Riker. Sid is back there. So. All right. All right, guys, that's it for me. Let me pull this over here. That's it for me. Thank you for joining us today. We did Daisy Link, and then we came over to Bionca. So appreciate you guys being in both of our streams. Thank you to our mods for doing a fantastic job as always. Thank you to Aaron. Aaron is working on the Halloween special. So I'll tease it a little bit more. We're going to do a Halloween stream, Halloween night. It's Friday night. So it's coming up in a couple weeks, probably start around 8 o'clock Eastern. and we're going to be playing a game. So we're looking forward to you guys participating. We'll ask you to participate over the next couple weeks, but we're working on an intro video for that. So definitely keep your eyes out for that, but I'll be talking about it more and more. But just try to keep Halloween night open. It's going to be fun. It's going to be a lot of fun. I think you guys will get a kick out of it. If you like playing games, you like hanging out, it's Halloween night. Come hang out with us. Have some adult beverages and chill out. And if you don't drink, then just hang out with us regardless. Whatever floats your boat is fine by us. So that being said, again, thank you all for joining us today. Thank you to our mods. Thank you to Aaron. And thank you for everybody that gave super chats, cups of coffee, memberships. We really appreciate it and appreciate you spending time with us. It's really cool that you spend time with us. So with that being said, I will release class for the night, and we'll see you guys tomorrow. Tomorrow, let's see. So Bionca Ellis is going to be live starting at 8. So that's going to be just verdict watch. So we'll dual stream. We'll do Bionca on the other machine, and here we'll do Daisy Link. Now Daisy Link should also be closing. Let's see. Defense should be resting, and then state's going to put on a rebuttal. Daisy's just been a complete, freaking show. I mean, I've never seen anything like that case. So definitely join us for that. Oh, you know what? I got to end this poll. Let me end this poll before we go. All right, let's end this poll. And tomorrow I'll also go over a lot more as far as our polls, and I'll recap what happened. I'm just really tired right now, so I want to go get some food and then go to sleep. So all right, 94 votes. Do you think Bionca is guilty and aware of her actions? 67% thought that. 19% thought not guilty, reason of insanity. 14% said need to sleep on it. So fair enough. We'll do some more polls tomorrow for sure. And with that, guys, have a great one. And also don't forget, we're going to have Psychosaurus Rex this Friday. We're going to have Psychosaurus Rex on. We'll be talking about Bionca Ellis. We may have a verdict by then. We'll be talking about that. Yes. So we'll be talking Psychosaurus Rex. So bring your answers, bring your questions. Bring your questions, and hopefully between the two of us, we'll be able to answer your questions. So bring your questions on Friday. We're not quite sure when, probably 4 or 5. Well, more like 6, probably 6 o'clock. So 6 o'clock Eastern, maybe a little bit later, not quite sure. But bring your questions, and hopefully we'll have answers. And until then, we'll see you tomorrow, and have a good night, guys. Bye.